You can put your hand on that table, Mr. Craig.
Discussing Mr. Bragg's case.
Okay, just have a seat.
I think I have two clients on Zoom.
Okay, hold on a minute. One of your clients,
Yes, I understand.
you should be here in person.
Well, I did not know she had two warrants, obviously. So
Okay,
I do understand that if you have two warrants, being on Zoom is not a good thing, but, I was certainly not aware of it. And
well, we're
so
gonna reset her. I mean, she's gonna have to be here tomorrow. Okay,
what's the name?
in person.
Tawana Leger.
Yeah, she need to be here tomorrow in person.
Uh, I understand that, and I do respect the court's opinion.
Yeah.
I have I can try to move something.
Yeah, because,
I have
Leger.
an appointment, a personal, medical issue in the morning. That I'll try to move it, but I mean, I agree with you. I mean,
Yeah,
I was made aware of it by, Deputy Mosley. as well,
yeah,
so I'm
yeah, I was
a
too.
little shocked, and, I'm gonna do my best to
Hey, Miss
schedule my appointment.
Miss Leger? Your mic is on mute.
Okay, I don't know how to take, I can't see you, Judge.
Well, that's fine. You can hear me.
Yes, sir.
Okay. Well, your case, you need to be here in person tomorrow at 9 a.m.
And Your Honor, I need to make sure that I can move this
Okay.
Okay.
thing that I have. I have a.
Okay. Well, that's fine. I mean, we have
Because
that during the
I know what's
daytime.
gonna happen, I mean.
Yeah. Okay.
Okay, sir.
So yours is reset until tomorrow.
Okay, thank you.
All right. All right. Stay in contact with your attorney, your bondsman.
Uh-huh.
All right. You're free to go.
Did you
Thank
make
you.
her aware that does she know she has the warrant? Okay,
Yeah.
fine, I'll.
Uh,
Make sure.
Okay. Hold on a minute. Let me.
DWI,
Okay. Let me pull that case up.
absolutely. Ms. Nixon, do you know who's on Marcus Mouton? DWI, I'm not sure if it's Mr. Williams or.
Move on.
DeMarcus. It doesn't.
Yeah, that's it. That's William.
Okay, well, we're fine with Mr. Williams.
Let me see. This is a 2025 case. Mr. Mouton, DeMarcus Mouton, cause number 25 CCCR 2218. Mr. Mouton, you can take your mic off of mute.
Yes, sir.
How are you doing, Mr. Mouton?
Good morning. How you doing, Judge?
I'm doing fine. Thanks for asking. Now, Mr. Mouton, you are represented in your case by your attorney, Attorney James Padgett. Let's see, Mr. Padgett, you sent a court a letter of representation back in December 2nd, 2025. What's your, I guess this must be your, we've had it 1, 2, this is your third, no, that'd be more than that.
It took.
What is this October 3rd notice of setting?
This case will go on your plea docket, Your Honor. I've received all the test results as well as the video evidence.
Okay,
All I need to do is, I've already relayed some of it to my client. It'll go on your plea docket. It'll be a plea search. I've
okay,
reviewed everything.
give us a, reset it for a plea.
If that's amenable to Mr. Williams.
This is a Mouton on page 8. Jaquan,
Yes.
DeMarcus Jaquan Mouton.
That's-
Yes, sir.
You want to reset it? This is April and May.
Okay.
If he's not agreeing, then.
May first, wait. In May?
Yeah, the next month. Cause this April.
Twenty-fifth, we're off, so.
Okay, what about Wednesday or Friday? I mean, we have to put it on Monday.
For sure.
May 28th, 29th.
And then.
May 29th. Okay, Mr. Paget. Mr. Mouton's case is gonna be reset to May 29th,
That's perfect, Your Honor.
2026 for plea.
And we need to make sure, can I tell him, Your Honor?
Yeah, the mic is right here.
Okay, Mr. Mouton.
Yes,
you'll
sir.
be Here in person on that day by 9 a.m.
Yes, sir.
And I'll contact you this week.
Okay, thank you.
Thank you.
Okay, you're free to go and you have a blessed day, Mr.
You as
Mouton.
well.
Okay. Okay,
So we have an issue here on restitution. It's an unusual situation that in 28 years of practice, I've never quite come across. My client has possession of a trailer that he leased, and after the lease period expired, he kept the trailer. It's stored in a shop. In the meantime, the victim is self-insured. They went and paid for a new trailer, for $700 for a new trailer that they now have possession of. My client has possession of a trailer that belongs to the company. So he can't sell the trailer and give them the difference. He's in possession of a stolen trailer technically right now.
well, that's what he's charged with, right?
That's exactly, well, keeping it past.
I see step property
That's exactly right. Step to property. So
greater than or
it's
equal
very
to
interesting.
$750, less than 2,500.
Well, technically the trailer, she says they pay $3,700 for a new trailer. So that takes us out of this range.
Out of what range?
Well,
But they gonna refile the case?
well, I hope not. We don't.
Well, I mean, it's already, I mean, this case is 750 to 2,500.
No, I understand.
That's what it said.
We're not, nobody's indicated that they are going to, Your Honor. Our issue is,
We're trying to determine
we're trying to
how to make
determine,
the big hole within it, but I'm still in negotiations with him as far as accepting. Because he still has the
He needs to
trailer.
give the
and I
trailer
want
back
him
to
to
the
go out, and look
and
at
it's
it.
worth something. So, in the meantime, I'm asking my client to take good pictures of the good photographs of that trailer to show them that it's in great shape and that they would want the trailer back. But he needs to get rid of possession of the trailer. He's in possession of a stolen trailer still as we speak. It's a little bit unusual circumstance because they've replaced the trailer with a new one.
Can't keep the trailer, it's not his,
I know.
first of all.
Well, he's ready to give back.
Okay, wait,
Ms. Nixon left
well,
time.
but I mean, I don't, I
Where do
mean,
we take the trailer?
oh, well, that's,
I don't want to-
that's neither
That's
here
what
nor
we're
there. I
negotiating.
mean, in terms of the case, you say, first of all, you came up and said, talked about restitution, and now
That's
you're
exactly
talking
right.
about
There's a-
the guy has a trailer that he don't know what to do with.
Well,
Okay, I mean, that's not gonna affect him, disposing of the case.
I think it will, Your Honor. Our position is that the trailer is worth a certain amount of money. He wants to give it back to him. He does not want to drive it back to the property and give it to him. So we need to know where to take the trailer.
I can't tell you where to take the
I'm
trailer.
not, I'm not asking.
If you
to-
saying something, you don't know where to take the trailer.
I'm
My,
asking, she is speaking with the complaining witnesses right now because they have a new trailer to see if they'll take the trailer back and offset the cost of the $3,700 that they're asking my client to pay. They're self-insured, so they paid out of pocket $3,700 for the new trailer.
yeah, no, but that's a restitution issue.
That's correct.
Yeah.
That is our only issue on the case, is the restitution.
They're just asking, can we ask for a reset 30 days so I can get?
We're not trying to stall or delay. I assure you, I've been in communications with Ms. Nixon over this.
Okay, how
And,
old is this case?
It's from August 2025. Is the August.
Well, I was hired in December of 2025.
Is this, hold on, this is, I'm looking at
That's
the.
my.
I was looking, okay,
second
let me pull up that file right quick. This is Greg, right?
Yes, Your Honor.
Travis A. Gregg. Okay, let's see what it says in here. Oh, so yeah, it says that you was hired December 16th
That's great, Your Honor.
of 2025. Let me pull up this here. Let's see, December. That be other. Bond. Shared bond. Let me see. Charges, custody, summer, maybe something summer. Let me see. There we go. Documents. Let me look under here. Oh, here we go. Hold on a minute. Okay,
Yeah, we're going.
Yes.
We'll be in Mexico.
what
Okay.
is,
We'll be in-
What about your?
how long you gonna be in Mexico? What's your,
I come back on the sixth, I can be in Florida on the eighth.
Can you give us a, vacation money? So
Yeah, I thought we'd already sent it, but I'll double check.
They don't. send
so,
it to us.
so your vacation's when to when?
That's from, May the 24th. Hang on, I'll give it to you, Judge.
Okay.
Let me get it.
May the 24th. I'm just wondering.
Okay, it starts on, this is April, it'll be in May. My vacation is, from, it ends on June the 5th. I'll be flying back, on
Let me,
the
let me,
5th.
um, court is back in session. Court is in session in cause number 24 CCCR 2326. Case is style of State of Texas versus Caleb Filia LeBlancis. Mr. Filia LeBlancis, would you please come forward? I think this is a terrorist here. Oh, yeah. I remember. This was a former, let's see, Mr.
Oh, it's a motion petition.
Yeah, it's a motion to revoke probation Remember this one. Mr. LeBlanc, your full name is Caleb Philial. Oh, yeah, Philial LeBlanc. Is that correct?
Yes, sir.
How you doing, Mr. LeBlanc? I'm doing fine. Thanks for asking. Okay. Now, Mr. LeBlanc, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. LeBlanc, you may put your hand down. How are you doing, Mr. LeBlanc? I'm doing fine. Thanks for asking. Now, Mr. LeBlanc, I have before me a motion to revoke your unadjudicated probation. This motion was filed by the Jefferson County District Attorney's Office. Mr. LeBlanc, in this motion, it alleges that you, Caleb Philial LeBlanc, was tried in County Court at Law Number 2 of Jefferson County, Texas, on February 26th of 2025 for the Class A misdemeanor offense of terroristic threat against a public servant. The court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt. And the court deferred the guilt and placed you on unadjudicated probation for a period of 15 months. Now, in this motion, there are 4 allegations. Allegation number 1 alleges that you, Caleb Philial LeBlanc, has failed to work faithfully at suitable employment as far as possible as ordered by the court in violation of condition 6 of your probation order. Allegation number 2 alleges that you failed to pay court assessed fees as ordered by the court as of February 5th of 2026, and you were $322 in arrears. Allegation number 3 alleged that you failed to perform community service hours required as ordered by the court in violation of conditions number 17 of your probation order. And allegation number 4 alleges that you failed to provide verification of attending and entering and successfully completing the Battering Intervention and Prevention Program, commonly referred to as BIP, or an approved anger management / violence intervention program, and pay all associated costs as ordered by the court in violation of the additional condition 18 of your probation order. Now, Mr. Philial LeBlanc, if the court finds that any one of these allegations are true, punishment can be assessed up to 1 year in the county jail. Okay? Now, as a defendant in a criminal case, you have 3 options regarding your right to have an attorney to represent you. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number 3, you may represent yourself. Do you understand those 3 options? All right. Now, if you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset, meaning that you'll be given another court date so that you can hire an attorney. If you want an attorney and do not have enough money to hire an attorney, you would need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Do you understand that? And also, I have before me an affidavit of indigence. Now, not allegation, but the next paragraph on judge's explanation of rights to defendants without attorney states that you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. What that means is that's for individuals who will be waiving their right to have an attorney or giving up their right to have an attorney. They will be representing themselves, and so they'll be acting as their own attorney. And so in order to do that, they have to first sign a waiver, waiving their right to hire an attorney. Do you understand that? Now, and for those individuals, this paragraph states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. And for those individuals who waive their right to have an attorney to represent them, it states that you may choose to proceed without an attorney, or if you choose to proceed without an attorney, you may change your mind at any time and may request an attorney to be appointed. Now, I also have before me in this document, it states defendant's choice, mark initials next to only one choice. There's a set of initials on a line next to a box that say, I would like to request a court-appointed attorney. Did you place your initials on this document? Okay, there's a signature on the line that is titled defendant. Is this your signature? I also have another document that is titled Jefferson County Affidavit of Indigence. And do you recognize this document? On page 2 of this document, there's a signature above the line that's titled defendant signature. Is this your signature? Now, Mr. LeBlancis, Phil y'all LeBlancis, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Phil y'all LeBlancis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you. And you will be given information to contact him. The court coordinator will give you that information. That's a public servant. Now, Mr. Phil y'all LeBlancis, do you have that, Ms. Mosby, do you have that form to CICE? The job now, Mr. LeBlancis, I see here, according to this motion, you do not have a job. Is that correct? Okay. Therein lies your problem. Okay. Because everything else is surrounded around that, with the exception of community service. So we have there's a program at Lamar University. It's part of is CICE. It stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry and in the shipping industry. Once you get a job, once you get trained in any one of those areas that you select, they will help you to get a job in in that area, okay? Now, I know when you came here the first time, we mentioned it to you during arraignment. And I think you were appointed, Attorney David Grove back then, weren't you? Okay. And when I see you here, your mom, every time you come, she's always with you, is that correct? That's your grandmother, okay. She looks young enough to be your mom. And so, she's always here, okay. Now, and I think I told you the last time that, you have the ability to correct, you make corrections in your life. I know, this is not the proudest moment of your grandmama's time seeing you here in court. But, some people might look at it as a stumbling block, but you could look at it as a stepping stone. And people use stepping stones to reach higher heights in life, okay? So, you're on probation. This is only a setback. And the reason why I say it's only a setback, because a setback, a minor setback is a setup for a major comeback. Okay? So you need to be on track for a comeback. Okay? Now, you were in high school when this happened, right?
Yeah.
Did you finish? Good. But that's a good thing. I'm glad you finished high school. That's good.
No.
But now you need to get to work and be productive. Okay? And you could do it. You're built for it. You know what? I'm glad you said that you're trying. Okay, we're gonna try to help you out because there are a lot of people who's not trying. Okay. And so hopefully, if you could get in contact with those folks, they may be able to help you out, where you can get some training, where you can get your education and get the training that you need to get a job. Okay, and I think Mr. Gilliam
Yes, sir.
is here. He's a probation officer. Just stay, now you're still on probation. Just because they filed this motion to revoke the probation doesn't mean you're off of probation. So you still have to do all the things that you're required to do while you're on probation. Okay, and we're gonna be looking, well, I say I'm gonna be looking at whether or not you're doing your community service, etc. You understand? Now, shouldn't have no problem doing community service because you're not working. Transportation. Well, you can talk to Mr. Gilliam. They can tell you places that you may be able to go that may not require a lot of transportation for you to get there to do whatever. Okay, so just your probation officer is the person that you need to stay in contact. Okay, and keep your probation officer informed as to your situation. Okay, because they're not here to hurt you, they're trying to help you. Okay.
She's here right now.
Hmm?
Ms. Reeves.
Oh, Miss Reeves is probation. Oh, I thought it was Mr. Gilliam. Miss Reeves.
Oh, I'm sorry, yeah.
Oh, I thought it was Mr. Gilliam. Hi.
I'm his officer.
Okay, how you doing, Miss Reeves? Now, Miss Reeves, she's with probation. Yeah, that's your probation officer. Just stay in contact with her. Kind of keep her informed as to your situation, okay? And you keep her informed. She's like the eyes and the ears for the court, and she'll keep us informed. Okay?
The major reason why an MTRP was filed was because there is a lack of motivation. He has never provided documentation that he's looking for work. His fees were actually converted to community service and no hours were done. So he got a really big opportunity when he first got probation. And because of he does report like he's supposed to, but his lack of motivation is the reason why we're here today.
Okay.
Because I couldn't see continuing him on probation when there's nothing
Okay.
going on with him.
Okay. I'm trying to figure out how can we get you motivated.
I think a good step is if he will get into this program,
Okay.
because then that will give a structure.
I tell you what, okay, when we have our next hearing, okay, they're gonna report to me as to the progress that, now, put it like this here, you give me a clean slate. We're gonna start today. Okay? Now you saying you're trying. When we come back, I'm gonna have it's like your report card. They're gonna show me what you did, and it's gonna let me know whether or not you are really trying. Okay, I know you say you got some transportation issues, but like I said, stay in contact with your probation officer, okay? Okay. And they're not trying to hurt, they're trying to help. Okay. Probation is rehabilitation. Okay. They're trying to rehabilitate you, make you productive so that you will not be in this situation again in the future. Okay. So look at it like that. Okay. I know you report, that's a good thing. That's a good thing. I don't mean to just look at it, pass over it, but that's a good thing. Keep on reporting, keep her informed, and they're gonna see, to try to help you so that you can be able to do the things that you're supposed to do on probation, okay? All right. So again, Mr. Wilkerson is appointed. Okay. She's gonna give you a reset. Once you get your reset, you'll be free to go. And before the day is out, you need to give that lady that you call grandmother a big kiss and a hug for being here with you. Okay? All right. Okay. You got a plea? Okay, you can stand over there. Mr. Rojas. Mr. Rojas?
Your receipt does not speak English, Judge. I'll be translating.
Pronounce the name again?
Asip?
Asip. Mario D. Asip.
Ask me that. I didn't be thinking.
Asip.
No.
Asip. Good. Ask Mr. Asip if he has gum in his mouth.
Yeah. Yes, she can.
That's your tourism.
Thank you, clear.
Okay. Okay, thank you. Rojas. Rojas. Asip. Okay, we have two cases.
6-1 is being dismissed. 6-1 is being dismissed.
Okay, it's a he's pleading on 6-0, okay. Okay. Jefferson County Court at law number 2 is back in session. The court is in session in two cases, cause numbers 25 CCC Aura 2860 and cause number 25 CCC Aura 2861. Both cases are styled the state of Texas versus Mario E. Asip. Mr. Asip speaks Spanish. His attorney Charles Rojas, is fluent in Spanish and English. And Mr. Rojas, would you please raise your right hand? Mr. Rojas, do you swear to interpret Spanish to English and English to Spanish? So help you God.
I do.
Mr. Rojas, you may put your hand down. How are you doing, Mr. Rojas?
Doing well, Judge. Thank you.
That's good. Mr. Rojas, ask Mr. Mario E. Asip if his full name is Mario E. Asip.
Yes.
And ask Mr. Asip to raise his right hand. Mr. Asip, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Asip, you may put your hand down. I'm gonna stop. Bien? That's good. Now, Mr. Asip, I have before me a document that is titled Information. This document was filed by the Jefferson County District Attorney's Office. In this document, it alleges that you, Mario E.I.C., on or about October 5th, 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, or transportation. Mr. I.C., do you understand what you have been charged with?
Yes,
And to this charge, how do you plead? Guilty, not guilty, or no contest?
guilty.
Are you pleading guilty freely and voluntarily? And are you, well, you speak some English too.
There gets to speak a little.
I just
Just like,
asked it.
just like you speak in Spanish, Dad.
Yeah, yeah, you speak
I
a
can
little
walk-
bit, huh?
walk.
Okay, so, Mr. I.C., are you pleading guilty because you are guilty?
Yeah.
Mr. I.C., I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes,
On page 2 of this same document, there are a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
yes,
On the next page of this same document, there's a signature above the line that is titled defendant. Is this your signature?
yes,
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
yes,
And is this your signature on the line that's titled defendant?
yes,
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement?
yes,
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand this statement?
yes,
Now, on page 1 of State's Exhibit Number 1, there are a set of initials below a paragraph that is titled Citizenship. Did you place your initials on this document?
yes,
Now, this paragraph states that if you are not a U.S. citizen on a plea of guilty or noli contendere, it may result in your deportation, denial of naturalization under federal law, and exclusion from admission to this country. Do you understand the statement?
yes,
Okay. And also, I have a document on paper that is titled Discovery Certification. Do you recognize this document?
yes,
And is this your signature on the line that's titled Defendant?
yes,
Now, Mr. Asif, before you signed and initialed these documents, did your attorney go over these documents with you in Spanish?
yes,
Did you understand everything that your attorney went over?
yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
State, you like to offer State's Exhibit Number 1?
so attended, Your Honor. No objection.
No objection. State's Exhibit Number 1 will be admitted, and Mr. Asif is from Guatemala.
Yes,
Mr. Rojas, you advising counsel, Mr. Asif. Is there any evidence that he's currently mentally incompetent to stand trial?
higher.
And Mr. Rojas, pursuant to the case of Padilla versus Kentucky, did you advise your client as to the consequences of him pleading guilty since he is not a citizen of the United States?
I did, Your Honor.
Okay. Mr. Asif, are you satisfied with the services of your attorney? And do you still want to go forward with your plea bargain?
Yes.
Okay. Mr. Asif, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
It will be a $500 fine, Your Honor, plus court costs, credit for 1 day time served, and the companion case ending in 2861 will be dismissed, Your Honor. Is that correct, Mr. Will? It is, Your Mr. Wood.
What's the court cost?
277. 862.
Huh?
562.
862? So it has to be 362 court costs. Okay, that adds up.
Assess it, if you lost that 277, we won't.
No, I'm saying, well, what's gonna be on the judgment?
You have a time.
Okay, that's what I need to tell her.
We also further ask to stay the Nittimus Johnson till next. The fifth of. The 5th of May.
Yeah, okay,
No objection by the state.
okay, 1 day, so that'd be. Okay. Mr. Asif. The state is offering that you serve, well, that you pay a fine of $500 plus court costs of $362, which comes to a total of $862. You have 1 day credit that will go toward the fine and court cost. The 1 day is $100. So your balance will be $762. And what's the date he's gonna pay it on?
Make it.
Okay. Okay,
And we're
and,
gonna try to do it today, Judge.
okay,
Make it just in case.
okay. And this amount of $762 is due and payable by May 5th of 2026. And would you be able to pay it?
Yes. Can you pay, he said, he can pay it early.
Yeah, he can pay it early, he can pay it, yeah, no problem. And the state will be dismissing cause number 25 CCCR 2861. Okay, oh, okay. Now, Mr. Asif, do you understand the state's offer?
Yes.
And do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Yes.
Okay, Mr. Asif, I'll follow the plea bargain agreement that you have entered into with the state. Again, Mr. Asif, the state will be dismissing cause number 25 CCCR 2861. All right,
It's ready.
yeah. Where's the bill? Just have a seat in that first chair and wait for your name to be called.
Yeah, we have the NTRP.
Okay, okay, okay. And this is that person here, Joel Della Garza? Okay. Mr. Della Garza, would you please come forward? What other than? Oh. Yeah. Mr. Della Garza, your full name is Joel Della Garza?
Yes, sir.
Well, how are you doing, Mr. Della Garza?
Little bit tired.
Oh, a little bit tired?
Yes, sir.
You had to drive in?
Yes, sir.
Okay. Now you are not Theron, right?
No, I'm Daryl Ward.
Okay, yeah. At least I got that for Daryl Ward. Okay, now, Mr. Della Garza, how are you doing?
Yes, sir.
You doing good? Okay, you're a little tired, but you're doing good.
Yes, sir.
You know what? I think you're gonna be doing a little bit better in a few minutes.
Please,
And Mr. Ward, Attorney Ward, how are you doing?
I'm doing well.
Okay, you had to drive in too, right?
I did.
Okay, you a little tired?
Very.
Oh,
Drive a lot.
okay. Well, we're gonna see if we can get you all out of here. Now, Mr. Delagarza, I have before me a motion to dismiss this motion to revoke probation. Is that correct, State?
That is correct, Your Honor.
And I'm signing this and that's the correct, Mr. Gilly?
Yes, sir.
Okay, I'm signing this motion to dismiss this motion to revoke probation. Um, you'll be able to get a copy of this motion from our court coordinator in a few minutes. Once you get a copy, you'll be free to go. You have a safe trip.
He'll still be in
You're still on probation?
till July.
Okay. And make sure that you stay in contact with your probation officer.
Sure.
Okay. And Mr. Delagarza, you'll be, once you get your copy, you're free to go and you have a blessed day and have a safe trip back home. And Attorney Ward, you have a safe trip back home as well and you'll be free to go.
Appreciate it. Thank you. Sir.
All right. Nice seeing y'all.
Thank you.
Okay. Okay. Okay.
Hey, good morning, Judge. I've just got one announcement whenever the court's ready.
Are we gonna say for the hearing? Do you want to present this, you know?
Walker,
How many cases?
Walker.
Ready, Judge.
Oh, no. Well, we're gonna do that one after. Let me hurry up and do Mr. Benoit, then we'll do Walker. Okay? I was looking for Benoit. There it is. Okay, hold on a minute.
For the hearing.
What was that, Galmore? Yes. Okay, this is cause number 25 CCCR 2916. Case is style the state of Texas versus Ronald Dale Benoit. Mr. Benoit is appearing via Zoom. Mr. Benoit, you can take your mic off of mute.
Yes, sir.
How are you doing, Mr. Benoit?
Doing good, Judge. How you doing?
I'm doing fine. Thanks for asking. Mr. Benoit, you represented by attorney Dustin Galmore. Mr. Galmore, how are you doing?
I'm great today, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Galmore, what is your announcement in Mr. Benoit's case? I see that you were hired on this case last month, September 17th, 2026.
Yes, Judge, we're still working on it. If we could get another announcement date.
Okay, have you received your discovery and an offer?
I believe I've seen the written discovery, but I can't confirm if we've received the media yet.
Oh, okay. Video, okay. Okay, give us a standard reset. This is on Benoit, page 3 of the announcement. This case will be reset to May 29th, 2026. Once you get your, well, Mr. Galmo, your reset will be sent to you. And Mr. Benoit, your attorney and your bondsman will be given notice of your reset. Stay in contact with your attorney and your bondsman. You're free to go. You have a blessed day. Mr. Benoit, on the next court date, you need to be here in person.
Yes, sir. Thank you.
All right, you're welcome.
No, thank you, Judge.
You're welcome. That's Mr. Crenshaw. Next case is Just is here, Walker? Oh, yeah, okay. Justin Patrick Walker. Mr. Walker, how are
Yes.
you doing?
I'm doing good.
That's good, Mr. Walker. You're represented by your attorney, Attorney Corey Crenshaw. Mr. Crenshaw, how are you doing?
I'm doing all right, Judge.
That's good.
Yeah.
And Mr. Crenshaw, what is your announcement in Mr. Walker's case?
There's a pending felony, Judge. We think the felony will be dispositive of the misdemeanor, but the felony is set for trial currently in August, and I know this court won't, want to reset it that long. So I would just ask for a standard reset on the pretrial conference docket. I'll see if there's a chance we can get the misdemeanor resolved.
Okay.
Prior to us putting on the trial docket, and if not, we'll just put it on.
Okay, give us a give us a reset pretrial conference.
I think I'm coming back on June 1st, Judge, if.
June 1st?
Yeah, already, if we
Okay.
put on the pretrial
She's gonna
conference.
put it on June 1st.
Great.
Okay, now, Mr. Walker, your case will be reset to June 1st. Stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day. On that day, you need to be in court in person.
Yes, sir.
All right, and Mr. Crenshaw, you're free to, well, you have another one.
I have another one, Judge.
Rayford Bruno?
And Judge, I don't know
Is he-
why we're requiring Mr. Rayford Bruno to come to court, because his case was resolved with a pretrial diversion.
Oh. Right, where's Mr. He? Could we look into that? Hold on a minute. Hold on a minute. Bruno. Is his name? Mr. Crenshaw, when was he placed on pretrial diversion? Was it just recently?
The signing from this month?
Okay, yeah, see, what happened was, when they have a pretrial, we usually reset the case after the signing date to see if they got into pretrial. That's why it was reset, and I know the state has changed its policy now. They no longer dismiss the case. Once they're placed in the pretrial, they have to, but we only did that for this one date. But since he's in pretrial, what's gonna happen, the case is gonna be placed in what is called an inactive status to see whether, and if once he completes pretrial, what they're going to do is eventually dismiss the case. And when it goes into inactive status, he would no longer have to report.
I understand that, Judge. It's just, I don't know why the client has to come to court and take off work after they've already signed the contract. I would hope that we could just put them in inactive status.
No,
after they sign the contract, if we could just put them in inactive status, then the client doesn't have to take off work and come to court.
Yeah, well, what happened was, the state has just changed the policy. Normally, we usually get those dismissals. We was getting those dismissals the day after they got into the pretrial program, and then the case would be dismissed, and they wouldn't, ordinarily they wouldn't be here. Because
I get that. So
Right.
I guess instead of the state submitting a dismissal, it'd be nice if someone could just submit a list of the people going to pretrial diversion, and instead of those clients having to show up to court, their
Right.
cases just be put inactive. That's how all other counties do it, and then you get a date basically in 1 year.
But this is, as I mentioned, this is the first month for that, and so that will be done.
Okay.
Okay, so this is the first time this has come up.
Okay.
Okay, so his case is going to be inactive. Only time he'll ever have to come back is if the state if he gets kicked out the program and the state activate the case again. Other
Okay.
than that, he would not have to appear again. Okay?
All right.
All right, so you're free to go, and you have a blessed day.
Thank you.
Okay. Yeah, he's not here, is he? Well, Mr. Bruno, yeah, is not here, so. Okay. This is cause number 24 CCCR 0990. Case the style of state of Texas versus Nadia Joe Rubin. Ms. Rubin, is that your full name?
Yes, sir.
Okay, Ms. Rubin, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Rubin, you may put your hand down there. Ms. Rubin, you're represented in your case by your attorney, Todd LeBlanc. Hey, Mr. LeBlanc. Mr. LeBlanc, how are you doing?
Good, Judge. Thank you.
That's good. Now, Mr. LeBlanc, yeah, we're gonna need a record on this. Okay. Now, Mr. LeBlanc, are you ready to proceed?
Yes, sir.
State, are you ready?
State's ready.
Okay. Now, I have before me a motion to revoke your unadjudicated probation. And this motion was filed by the Jefferson County District Attorney's Office. And Mr. Williams, you may proceed.
Thank you, Your Honor. With that, the state will call the probation officer within the court.
Okay. And so you're calling Ms. Jennifer Reeves, is that
That's
correct?
Your Honor.
Ms. Reeves, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Give me a copy of that motion.
Would it be easier, Judge, to proceed From this board, would you like her to take the stand and testify?
Whichever is convenient for you all. You can do it here, or if you want to do it over there, that's fine.
Okay. Good for you.
Hold on a minute. Did you make a copy of the? You know what? I may be able to get a copy from here.
She's speaking.
Okay. Ms. Reeves, let me swear you in. Ms. Reeves, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. And this is cause number 24 CCCR 0990. Case of style of state of Texas versus Nadia Joe Rubin. And Mr. Williams, you may proceed.
Ms. Reeves, for the record, just please introduce yourself to the court.
Jennifer Reed,
And where you employed?
Jefferson County Adult Probation,
And how long have you been employed?
23.5 years.
If you have, we round up to 24. I'd like to turn your attention to the probationer, Nadia Rubin. Are you familiar with Miss Nadia Rubin?
Yes, sir.
Was she placed on probation here in Jefferson County?
Yes, sir.
Do you see the person who was placed here on probation in Jefferson County? You see the person here in court today?
Yes, I do.
Could you please identify her for the record?
Oh, she's wearing a gray TDC outfit.
May the record reflect the in-court identification of Miss Nadia Rubin.
The record will reflect that the witness has identified Ms. Nadia Rubin.
Now, when did you initially come in contact with Miss Nadia Rubin?
When she was placed on probation in October 2025.
And in fact, she was placed on 15 months deferred adjudication, correct?
Yes, sir.
And while being placed on deferred adjudication, she had several conditions of that deferred adjudication, correct?
Yes, sir.
Now, within this case, and after a administrative hearing, which was held, several items were identified within the state's motion to revoke the probation, correct?
Yes, sir.
The first item is that she was not depleted any of these things, correct?
Yes, ma'am.
And that she was in fact charged with the offense of driving while intoxication back in November of 2025, correct?
Yes, sir.
An additional condition was that she was not supposed to become intoxicated, correct?
Yes, sir.
And in fact, I think it was on, is it November 13th or November 14th that she had in fact become intoxicated
Yes, sir.
of 2024.
Yes, sir.
For the record, what other conditions that she had, which are delineated in the motion to revoke the probation?
She failed to report as directed. She failed to report on November the 13th of 2025, December the 9th of 2025, December the 18th of 2025. She was also in arrears in the payment of her fine costs and fees, and it is currently in arrears for $460. She also had a condition of probation where she was not to operate a motor vehicle without the interlock installed, and on the date that she was arrested, the vehicle did not have the device.
Now, since November, when she became intoxicated, when she got arrested, when she did not have the interlock device, have you had conversations with Ms. Rubin?
Prior to this,
No, ma'am.
After?
Yes, ma'am.
until she was arrested on the motion to revoke probation.
Were there any telephone messages regarding her conditions of probation. So the reason why she has not, why she missed those dates, reporting dates to come to the office, was there any contact on behalf of Ms. Rubin?
Not until she was arrested on MTRP.
Did she do anything, anything that you can, provide to the court to comply with her conditions of probation?
Are you asking, has she done anything
Yes,
to
ma'am.
comply?
Yes, ma'am. I heard that she was, in arrearages on her pay, but has she made any payments? And then I'm going to ask you, I want you to look at, has she made any payments before the middle of November of 2025, and then after November 2025?
She did not make any payments prior to the arrest in November. She has made one payment in February of $502.
Let me ask you this, based on the reason Mrs. Reed, what's your recommendation in this to the court?
My recommendation is revocation with the maximum jail sentence.
Why do you make that recommendation?
Even since the MTRP has been filed, there's been blatant disregard for the court.
Also,
I feel like she has continued to drink. She's continued to not do what the judge asked her to do. She actually was dishonest with the court, informing the court that she was not driving. And in fact, she was driving. She has tested positive for alcohol in her urine on 2 separate occasions since the motion has been filed. So I feel like if we are to hold her accountable for her actions, her continued actions, even after the motion is filed, revocation is the only option.
thank you, Mr. Reed. Stay with tender the witness.
Mr. LeBlanc,
When was she placed on probation?
October the 1st of 2025,
When did she just arrest?
November the 12th of 2025.
And when was the motion revoked? Filed?
The motion was requested. The administrative hearing was submitted December the 19th of 2025. It was signed, the warrant was issued January the 16th of 2026.
And so you're saying that since that arrest, she's made contact with the probation department?
Yes, she reported once that had occurred.
Has she continued to report?
She has continued to report.
So since that arrest, you're asking for revocation. Is it based on that arrest only?
No, sir.
And you don't know anything about the facts of that?
No, sir.
She's not guilty of it at this point, is she? Has it been filed? You know?
I do not know.
And that was 1 month, a little over a month after she got probation term.
Yes, sir.
Okay. And you're recommending the max because what did you say? She's disregarding the court's.
She's continuing to violate her probation and has had no regard with what the judge has ordered her to do because of that.
And when did she violate that? What are you talking about? What?
And on January the 29th of 2026, after she turned herself in on the MTRP, she reported to my office and was under the influence of alcohol.
So she was under the influence of alcohol. Now, is it the same as the test that?
She blew numbers and then tested positive with the urine. She did both. And then when she was in court, I believe, I do have when she was in court on April the 8th of 2026, she did not blow numbers in the device, but she did test positive for alcohol in her urine. So she had drank within 72 hours of the test being done.
And what's the date of it?
April the 8th of 2026. And then she came to court, I believe it was in March, if I'm not mistaken, and told the judge that she did not have access to the vehicle and was not driving. Upon leaving court, myself and another officer observed her getting behind the wheel of a vehicle and attempting to drive off in that vehicle.
You all followed her out to the parking lot?
Yes, sir.
And why'd you do that? I don't think you do
Because-
everybody.
Because she came to our office the same way. She told me she was not driving. And she had keys in her pocket, so I asked for her keys because she was under the influence. Ended up, she drove a vehicle. She said it wasn't keys to a vehicle in the parking lot. It was keys to a vehicle in a parking lot.
And so you think that these events have happened, that she has problems with alcohol? Take it. That's what y'all think, right?
Yes, sir.
Has she been in treatment or anything? Do you know?
She was instructed on March the 5th to enter and complete a substance abuse assessment with ATAR. And also at that time, she was to either have, I was under the impression it was the scram, but I think the bond conditions say scram or mobile device. She was instructed to come to my office the next day so that I could have her sign the paperwork to send the referral over to ATAR and also to give her the paperwork to get the device. And she no-showed for that appointment and did not report to the end of the month when her actually scheduled appointment was.
Is she, and as you can tell, she's currently employed. Did she make the $500 payment?
Yeah, that was in February. She's still in arrears $460.
She's still in arrears.
Yes, sir.
That's where they are.
Okay, Mr. Williams,
Respectfully, Judge, the state will call 911.
that's,
There's no right against in this proceeding.
Well, I don't know about that, Jeff.
anytime there's a potential for her to go to jail, you have even if it's quasi-criminal, she has a right against self-incrimination.
She's on the order of the court for the order of probation, Judge.
I understand.
That's the court's ruling, okay, Your Honor.
Yeah.
So the court rules that the state cannot call.
No, I'm just saying, if she invokes her Fifth Amendment right against self-incrimination,
But she had, Judge.
well, her attorney,
Judge, I think if it's a court limit, there's a new offense pending, and she does have right not to, if the court will limit to the administrative allegations, she's not gonna answer any questions about any new offense pending.
I will not touch the new offense.
Okay. Thank you.
okay, so she's waiving. Okay. She's already been sworn in.
Good morning, Ms. Rubin. Ms. Rubin, I will cut right to it. We see that you are employed. Have you availed yourself to the employee assistance program, which is offered through the state of Texas? That you have, and when you say that you have enrolled or participated within the program, are you currently doing that?
Yes, and I go to AA meetings.
Is there a sponsor within the AA meeting?
Yes, yeah. Okay.
When you availed yourself to the EAP or the Employee Assistance Program, was there an evaluation that would have been done?
Yes.
Were you ordered in the treatment, outpatient treatment or inpatient treatment?
Okay.
Are you currently enrolled in outpatient treatment?
Yes.
Can you kindly tell the court why it is that you did not, have you supplied this to the probation office?
Well, I
Yeah.
just,
Sorry, go ahead.
they just email me everything that I need. But I've been going to get help myself. I don't drink, I've been drinking.
How can you say, respectfully, now, you say you haven't been drinking, but not more than, 3 weeks ago, you appeared, within the office, and in fact, you have been here. It was tested shown in your urine.
I've been getting healed. He's testing today, I'm come clean.
Let me ask you this. How can the state, how can the people of Jefferson County be safe from you getting behind the wheel of all intoxication? What assurances that you can provide?
Cause I got, my sponsor told me I need to serve, probably to fix the problem by getting healed. If you don't get healed, you still in the party. So my number one thing is to get healed. Myself.
You understand though, at this point, the help that you've been seeking, the help that you've been receiving has not resulted in the safety to this community. Do you understand that?
I do, but I have not been drinking, not at all.
Since we know at least can go back 3 days, so we know for a fact that you drank as late as April 5th of this month. Correct? Correct? Yeah, you have to understand. Yeah. But you also told Ms. Reeves, your probation officer, that you hadn't been drinking at all, even at that point, correct?
Yes,
Okay,
but,
I'm sorry, go ahead, man.
but when you have a problem and you don't know you have a problem and you finally get help, it's different. It's seeking help to your needs for safety and for anything. I'm trying to get myself help for me.
Then would you be willing, since you are employed by the great state of Texas, there is an employee assistance program, you can go into an inpatient for at least 90 days, and then we can revisit this. We can hold this in abeyance for 90 days. Are you willing to go into an inpatient treatment because it is covered by your insurance? It is covered by the employee assistance program. You willing to do that for 90 days?
Of course.
Then once she gets enrolled, I ask the court that we could continue this hearing. Ms. Reeves? What do you think? We can continue the hearing, but she has to enroll into an inpatient treatment,
Okay,
If I may.
okay,
at least for 90.
okay.
That may be our recommendation, but don't they make a recommendation at the, I mean, if that's what they're recommending.
The minimum probably be like 30.
Renewable, that's not, I'm sorry.
I'm sorry.
Let me go
Okay,
ahead and get you
But
to a
I-
version, then I can let Ms. Reeves. I've done research into this. I know.
okay. 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 Let's see, she was placed on in October.
I would just
Can I ask a
request it
question?
needs to be quick,
What need to be quick?
like her getting into their, like,
Okay,
you know, time frame.
okay, okay,
I will also,
okay, no, okay, this is, let me see, this month.
Judge, it's also through the EAP program, there are also beds are being available.
Understand,
for people
okay,
who
this is,
just-
okay, this is what I'm gonna do. We will, okay. The court is gonna, find that conditions, and I was just going on, conditions 2 and 3, we're gonna find those to be true. Okay? I mean, I get no testimony other than, to prove that she had an offense that she was actually guilty, not guilty, but enough, by preponderance of the evidence to prove the DWI.
Oh, we did, yes, sir.
Right.
Up to that point, Judge.
And then, the driving car did not have an interlock. I mean, we didn't, other than what she said, that that's part of the charge of the DWI. But the court can find either one allegation, we can revoke a probation. Now, what we're gonna do, we're gonna revoke the probation and amend and extend it for a year. And part of that year extension is gonna be that program that he talked about. We're gonna modify it to, you have to get into that program. Okay? That's gonna be a part of your probation. Yes.
Like, supervisor, we don't have enough, so
What are you talking about?
it work, yes.
Oh, yeah, well, what we right now, we talking about you getting into that program. Man,
But.
okay, I now, I don't, Mr. Williams, do we have the name of the program? As you said, it was an employee assistance,
It's an employee assistance program through, the state of Texas, Judge. And it's within, they also have correction officers. It's there, it's within their manual, it's with the employee, manual.
okay,
Ms. Reeves may also have, additional details about the program, but additionally on it, if that isn't the program,
would they have a
let me
program?
say this, with the EAP, they do like an evaluation, everything over the
Right.
phone, but even if they do not have that, Judge, as the court is well aware, there's Franklin House South. Their
Okay,
inpatient program, the key is for an inpatient program. And we think after, I mean, for a period of,
Or-
they gonna recommend a period of
Well, we
90 days.
all we can say, that program, and if that program is not available, then we can do a inpatient, another appropriate inpatient program. Is that,
Yes, sir, Judge, that
Okay.
would be ideal.
okay, now, all the other terms and conditions of probation are still in effect. Okay, so your probation, normally we're gonna amend it and extend it for another year,
Okay.
okay?
Yes, sir.
Okay,
Judge, my only concern is I don't think that court can force her into them to agree. Do they make an assessment? And if she needs the inpatient or if there's outpatient, the least restrictive. She was talking about her job, I think.
I understand, well, but
Your Honor.
at this point, the court is under the impression that she said she need help.
Right.
Okay? And so, we all agree, including her, that she needs help, and we're trying to give her the help that she needs.
Understand.
It would be the issue that we see on the state side, Your Honor. The issue would be when she speak with her employee assistance program through the insurance judge, that's a telephone call. We have no, mechanism to knowing how candid she would be. It could be minimized, and then that's when they will, what appropriate program would be for you to do X. I mean, it has to be, and if you have someone.
It appears that she's willing to do X anyway, so that's, whatever, I'm just saying, if they recommend that, I mean, I don't know how we can tell them to take her into inpatient. I think that's my understanding, they would make that decision.
If they don't,
If
we have
they-
the alternative.
Right, we have,
It
right,
would be to me, it's the same as him, if he was a felony judge, ordering safe P.
right,
Like we can order inpatient treatment
Right.
as a condition of probation. So the
Right.
thing is she gonna be honest and let them know the issue? Because right now she's saying she's attending AA, that's support. That's not treatment.
that was just a condition of a bond.
Yeah.
That's all that was for. Right.
Yeah.
And I'm
But,
not saying AA is enough, I mean, but there is different.
but that was just as a condition of a bond now, and we talking about probation conditions now.
I just read it.
And so all of the conditions still apply that, she's still on probation, all those conditions apply, but she has to do, the assistance program through her employer, and if that's not available, then we do an alternative outpatient
And she's
at a place that's
Spindletop,
recommended by,
Yeah.
right. Okay,
All right.
so we understand? Okay,
Either with EAP or a facility, anyway, it needs to be at least 90 days.
And you had a 1 year extension on
I
that?
did,
Okay.
and the 1 year extension with no additional.
Right. Okay, and Ms. Reeves,
Above defendant.
LeBlanc, you'll be free to go?
Just add one more, but yeah.
Miss LeBlanc,
Hang on, certain.
LMNOP. Is it on the MTRP docket? Okay, Rebecca Kano. Okay, cause number 25 CCCR 1734, case of Styles, State of Texas versus Rebecca Kano. Ms. Kano was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Rebecca Kano at the courthouse door. Rebecca Kano did not answer. Rebecca Kano has not appeared in court since the court has been in session. The time now is 11:21 a.m. on today's date of April 29, 2026. Ms. Bailiff, would you please call the name of Rebecca Kano at the courthouse door? Okay, Rebecca Kano's name was just called again at the courthouse door. Rebecca Kano did not answer. A reasonable time has passed to give Ms. Kano opportunity to appear in court. She has not appeared in court. State, do you have a motion?
One moment, Judge, I'll just check and see if he's in this.
Oh. I see that. Is that person here?
That's past the Hawkins.
Ms. Coffin?
Mr. Charles, I believe, haven't received it.
Okay, he's still. Okay, you still checking?
Yes, Your
Okay. Now, Miss, while you doing that, I'm gonna call up Miss Coffin's client. Yes.
Whether if it is or not,
Yeah.
then she'll.
Yeah, you.
My child's in custody, Your Honor.
Okay, so,
Oh, sure.
okay, so this case is being dismissed. Ms. Carlton, you'll be able to get a copy of the dismissal and you're free to go and you have a blessed day.
Your Honor.
If necessarily, there are 4 felons that arose out of the 7. This is, I don't see how it's 5 Blackbird.
She's on probation. She's still on probation. We don't have,
Thank you, I appreciate it.
we don't have to reset anything.
Okay.
The case is disposed of. It's just like yeah.
You want a copy?
No, we're not gonna, yeah. The probation officer will let us know if it's needed status is needed.
Did you?
As for Miss,
Did you want one of these? Miss Ruby? Mr.
as,
Okay, I just signed that dismissal. Ms. Carlton, you're welcome.
okay. As for Ms. Pino, Your Honor, they had an opportunity to review, well, she's not in custody here in Jefferson County. Therefore, by her now not being present, the state moves for a bond forfeiture and a warrant issue.
Okay, that Rebecca Kano's bond will be forfeited and a warrant shall be issued for her arrest in this case. Okay? Ms. Barraza? Taranisha O'Neill, she's on Zoom. Miss O'Neill, you can take your mic off of mute.
Hello?
Yeah, Miss O'Neill, how are you doing?
I'm doing good.
That's good. Now, Miss O'Neill, you're represented in your case by your attorney, Attorney Laurie Perrazzo. And Ms. Perrazzo, how are you doing?
Doing well, Your Honor, thank you.
That's good. Now, Ms. Perrazzo, let's see, I'm gonna pull up Miss O'Neill's case. And Miss O'Neill. Miss O'Neill. What's this? Okay, now, Ms. Perrazzo, what is your announcement in Miss O'Neill's case?
So we have received an offer, and without going into detail,
Okay,
my client would like to reject the offer at this time.
Okay.
And have her case placed on the trial docket.
okay, give us a setting for trial.
June first.
Okay, okay. Let her check out the schedule.
I'm actually scheduled to be in, county court or CDC for sentencing and then a trial setting as well.
What about June eighth?
I'll be here.
June 8th? Okay, this case will be reset to June 8th for trial at 9 AM. Now, Ms. O'Neill, your
Yes, sir.
attorney and your bondsman will be given notice of your reset date. For your court date, you need to be here in person on June 8th, 2026. You'll be free to go. I'll stay in contact with your attorney, your bondsman, and you have a blessed day.
You too.
Okay, and you're free to go as well, Ms. Ferrazzo. Miss, anybody ready? Marva. Who's where? Okay,
I'm putting off the discovery,
okay, Kiara Hightower is on Zoom, Miss Provo. Miss Hightower, you can take your mic off of mute. How are you doing, Miss Hightower?
I'm good. How are you?
I'm doing fine. Thanks for asking. Now, Ms. Hightower, you're represented in your case by your attorney, Attorney Marva Provo, who is present in court. And Ms. Provo, how are you doing? That's good. Let's see. Okay, now, Ms. Provo, what's your announcement in Ms. Hightower's case?
I need to speak with my client, and if the offer has been made, I can support it.
Okay, now, Ms. Hyde, okay, we're going to, now this case is I think you were appointed October 9th of 2025.
Yeah. It's not a good.
No, it was September of 2025. September, October. That's seven months.
What's offered?
You can talk.
Who, so
Who does she want to come in and plead or?
I'm gonna reset it 2 weeks. Okay? I'm gonna reset it. Okay, when your vacation starts.
It's on vacation.
This Tuesday?
2 weeks, yes.
Okay, when does it end?
Yeah, I had them.
Okay, so what, the date right after May 21st?
It's 22nd.
Well, we're doing that, but we have one on May 26th. It'll be on Tuesday. What did we got at Wednesday?
Okay, good. We could put it on a Tuesday. Okay, so this case will be reset for a plea on May 26th. Is that correct? And Ms. Hightower, on May 26th, your case is set for a plea. You need to be in court in person.
Yes, sir.
Okay, so you need to be in court in person. You stay in contact with your attorney, your bonds, and they will be given notice of your reset date. Again, it's May 26th of 2026 at 9 AM. You're free to go. Stay in contact with your attorney and your bondsman. And you have a blessed day.
Thank you, you too.
You're welcome. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. They are cause numbers 26 CCCR 0500 and cause number 26 CCCR 0501. Both cases are styled the state of Texas versus Denise M. Ware. Ms. Ware, is that your full name?
Yes.
How are you doing, Ms. Ware? That's good. Now, Ms. Ware, you're represented in your cases by your attorney, Attorney Giles Cole. And Mr. Cole, how are you doing?
Great, Judge.
And Mr. Cole, do you waive a record in Ms. Ware's cases?
Yes, sir.
The state is represented in these cases by Attorney Samuel Masradian. Attorney Masradian, how are you doing?
Doing well, Judge. Thank you.
That's good. And Ms. Ware,
Sir?
let me see, did I swear you in?
No, sir.
Okay, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Ware, you may put your hand down. And Ms. Ware, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office in cause number 26 CCCR 0500. In this information, it alleges that you, Denise M. Ware, on or about November 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Ms. Ware, do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
No.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yeah.
And Ms. Ware, I also have before me on my computer, a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are a set of initials on a line next to boxes checked no contingent, which means no contest. Did you place your initials DMW on this document? On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, it is.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, it is.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, I do.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, I do.
You had a discovery certification.
Yes, sir.
Okay, I also have another document that is titled Discovery Certification. Do you recognize this document?
Yes, I do.
Now, Ms. Ware, before you signed and issued these documents, did your attorney go over these documents with you?
Yes, she did.
And did you understand everything that your attorney went over?
Yes, I do.
And is everything in these documents true and correct to the best of your knowledge?
Yes, it is.
Ms. Ware, are you a citizen of the United States?
State offer states one, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. And Mr. Cole, you've advised in counsel, Ms. Ware, is there any evidence that she is currently mentally incompetent to stand trial? And Ms. Ware, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, I am.
Has he provided full, effective, and competent legal representation?
Yes, I am.
Okay, Ms. Ware, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, Do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That'd be 10 days in the county jail with 10 days credit for time served.
Ms. Ware, the state is offering that you serve 10 days in the Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail, any more time in the Jefferson County Jail in this case, because you've already served 10 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Ware, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Ms. Ware, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Ware, we'll move on to your next case. And your next case is cause number 26CCC-AURA 0501. And in this case, I have a motion, well, I have a information that was filed by the Jefferson County District Attorney's Office. In this information, Ms. Ware, it alleges that you, Denise M. Ware, on or about November 25th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Ms. Ware, do you understand what you have been charged with in this case? And to this charge, Ms. Ware, how do you plead? Guilty, not guilty, or no contest? Now, Ms. Ware, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Ware, I also have another document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. And Ms. Ware, do you recognize this document?
Yes, sir.
On page 2 of this document, there's a set of initials DMW on the line next to a box that's checked.
Yes.
No, the contender, did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document, that's titled trial court certification of defendant's right of appeal. Do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Now, the second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Yeah, that discovers.
Yes, we need the second one. I'm filling out right now, Your Honor.
Okay. Oh, you did put both of them?
Yes.
Oh,
Okay, now, Ms. Ware, let me get that, give me that other one back, yeah. Ms. Ware, I previously showed you this document that's titled Discovery Certification, and you acknowledge that this is your signature on this document, right? Now, before you signed and initialed all of the documents that I showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
state offer states 1, Your Honor.
Purchase.
No objections. State's Exhibit number 1 will be admitted. Ms. Ware, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor. It'd be 14 days in the county jail with 14 days credit for time served, court cost, tax, and retired.
Okay, Ms. Ware, the state is offering that you serve 14 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you already served 14 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will also be taxed and retired, which means you will not have to pay it, the court costs. And therefore, the court costs will be taxed and retired because the time that you spent in jail has already paid it off. So, Ms. Ware, do you understand the state's offer? Do you think the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Ware, I'll follow. People are in agreement that you have entered into with the state. Now, Ms. Ware, you'll stand next to the bailiff, follow her directions. Once you finish following her directions, you're free to go. And you have a blessed day.
You too, thank you.
Thank you. And Mr. Cole, these are your last two cases. You're free to go, and you have a blessed day.
These. Long good with this one.
All of this here goes together, I think. What is this here is what it took?
Oh. That might only be for one case, just.
Denise Ware. Hmm?
That might only be for one case. This says both cases.
Oh,
Since the discovery report had both numbers on it.
okay, so you don't need these. He doesn't need these, you know, here. Ms. Ware.
Yeah, she get to come in with someone, so it's welcome. I want to make sure it's welcome.
Okay, here we go. Mr. Lage, what are we doing on her? Do you have anything else? Oh, she's typing up.
I do not, when if you want to.
Okay, that's fine.
You're not? No. If you'd like. Yeah.
That's fine.
Mr. Martinez. Hmm? Yes.
Okay. Armando Roberto Martinez. Mr. Martinez, your full name is Raimundo Roberto Martinez.
Yes, sir.
How are you doing, Mr. Martinez?
All right.
I'm doing fine. Thanks for asking. Ms. Martinez, you're represented by your attorney Jennifer DeLage. Ms. DeLage, how are you doing?
I'm doing great, Judge. How are you?
I'm doing fine. Thanks for asking. I'm just trying to figure out why this case. This is an old case, but it appears that you were appointed last month.
Yes, Your Honor, I was recently appointed.
Let me find out. Was he recently arrested? He might have, hold on, let me find out.
Never got any information on this, that I had a case on this until I ended up finding out I went to jail. So.
Oh,
Yeah, they never told me anything.
so the case was filed.
He didn't realize the case was filed.
Yeah, the case was filed in September of 2024. And you did not get arrested until January 30th of 2026. Okay.
I had no clue I had.
Yeah, okay. So this is your first court
Yes.
appearance.
Yes, Your Honor.
Okay,
Actually, I think the state wants to make the announcement here, Judge.
okay.
Yes, when I was trying to review all the documents, I was unable to find a criminal history report in my documents. And I would like to reset the case in order to make sure we have it on file and.
This is about before you make your offer.
Correct.
That's what you're saying. Okay. Now, have you received discovery?
I
You have not, we're about to send it to you.
have not. I thought I had requested it, but I hadn't received it, is about what I was supposed to say.
Okay, so we're gonna reset this. We're gonna give a standard reset at that time. We should have discovery and an offer from the state.
Perfect.
Okay? So Ms. DeLage, yeah, your client can have a seat. You're gonna get your reset. Once you get your reset, you're free to go and you have a blessed day.
And Kevin.
Hmm?
He's ready?
Ooh. Clifton Alton Keller. I'm gonna get it. I'm gonna read that to him at the end.
Yes, Your Honor. He just needs it.
Oops.
like I said, he's been on the air, so almost like the least. Is this Kelly, Mr. Kelly?
Yes.
Yes, sir.
Yes, Cornelius, I just called you your honor. You spoke very.
Okay. This is clause number 25 CCCR 2930, case is style the state of Texas versus Clifton Alton Keller. Mr. Keller, is that your full name?
Yes, sir.
Mr. Keller, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You may put your hand down. Mr. Keller, you're represented in your case by your attorney, Jennifer DeLage. Ms. DeLage, do you waive a record in Mr. Keller's case?
So waived, your honor.
Mr. Keller, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Clifton Alton Keller, on or about August 20th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury to a family member. Mr. Keller, do you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead guilty, not guilty, and no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Keller, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on the line next to boxes checking on the contingent. You should place your initials on this document.
Yes.
On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have another document that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Mr. Keller, before you sign and initial these documents, does your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Keller, are you a citizen of the United States?
Absolutely.
State offer, state upon your honor.
Any-
objection.
No objection. State's exhibit number 1 will be admitted. Mr. Lodge, you have advised and counseled Mr. Keller. Is there any evidence that he is currently mentally incompetent to stand trial?
No, your honor.
And Mr. Keller, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Sir.
Mr. Keller, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Let's see. Now, did you offer states 1?
Yes.
Yes.
Okay. Okay, now, Mr. Masradian, is there an offer in this case?
Yes, your honor.
And what is the offer?
180 days in the county jail with credit for 139 days.
Credit, okay. Okay. What's the court cost in this case? Okay, 2 cents, okay.
We're off tax and retired, correct?
Correct.
Well, he didn't have enough, but, what we got, I'm gonna give him this here. We have this affidavit. Man, this here was thick. Oh, here it is right here.
Yeah.
I don't think I need to be right here. Okay.
Thank you, Judge.
Now, Mr. Keller, the state is offering that you serve 180 days in Jefferson County Jail. You've given credit for 139 days. The court cost in this case is $277. Are you able to pay the $277 court cost?
No, sir.
Okay, your attorney has a document before you that is titled Affidavit of Indigence. Do you recognize that document? Is everything in that document still true and correct?
Yes, sir.
Okay, Mr. Keller, the court is gonna find that you're indigent, and based on the finding of indigency, you will not have to pay the $277 court cost because the court has found that you're indigent, and that's pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Mr. Keller, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case and the findings that has been made, the findings that have been made by the court is fair and just. And do you accept it?
Yes, sir.
Okay, Mr. Keller, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Keller, I'm going to give you a document. Well, your attorney has a document before you that is titled Model Written Ammunition on Ineligibility to Possess Firearm or Ammunition. I'm going to go over this document with you. And it states, in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonish you or warns you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have any questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013, firearms mean any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. B, firearms does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46 that is one, an antique or carrier firearm manufactured before 1899, or two, a replica of an antique or carrier firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long you're ineligible to possess a firearm or ammunition lasts, the court recommends you contact an attorney. For your reference, you may wish to consult the statutes listed below, which may or may not apply to your circumstances. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 27.14E1, plea of guilty or no contendere in a misdemeanor case. Code of Criminal Procedure, Article 42.0131, notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, unlawful carrying weapons. Penal Code Section 46.04, unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders and conditions of bond in a family violence, child abuse and neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective order. Now, Mr. Keller, the written ammunition that you have in your possession is for you. You will stand next to the bailiff, follow her directions. Once you finish following her direction, follow the bailiff, and you have a blessed day. And Mr. Lodge, or Mr. Ledge, is this your last case?
Yes, Your Honor.
Okay, you're free to go,
Thank you.
and you have a blessed day.
You too.
You're welcome.
Thank you.
Do I have anybody on Joe anymore?
On what? Joe, go close the door.
What can we say, what we have to know? And what can we do to try to come to the lives of the here?
Oh, God, he doesn't know. He's not credible. But he's on the side, you know.
Well, he wrote something, this is the-
But I mean, he's got these. Oh.
What is I just have some paperwork for him. Now, Mr. Denton, let me do this here. CCCR 2126.
Sam, step up for me, please.
Yeah, it's just, it just been recent. It's not. Do we have, Mr. Denton's? Let me pull up his, MTRP. I'm gonna pull it up on the computer. This is Randall. Okay, Mr. Denton, your full name is Randall G. Denton. How are you doing, Mr. Denton? I'm doing fine. Mr. Denton, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Okay, now, Mr. Denton, you have a motion to revoke your probation that was filed against you by the state of Texas, Jefferson County District Attorney's Office, to be more specific. And this motion alleged that on December 9th of 2024, while you was in Jefferson County, Texas, that you was tried in County Court at Law Number 2 for the Class A misdemeanor offense of driving while intoxicated. Second, the court found you guilty and assessed punishment for a term of 180 days confinement and a fine of $1,000. You was placed on probation for a period of 15 months. During this 15-month period, the state alleges that you violated your probation. And there are 7 allegations. The first allegation alleged that you failed to pay court assessed fees as ordered by the court. And as of October 30, 2025, you used $1,240 in arrears in violation of condition 9 of probation order. Allegation number 2 alleged that you failed to submit to alcohol and or drug screening on or about August 5th of 2025 as directed by the Jefferson County Community Supervision and Correction Department or supervising jurisdiction in violation of condition 16 of your probation order. Allegation number 3 alleges that you failed to perform community service hours required as ordered by the court in violation of condition 17 of your probation order. Allegation number 4 alleges that you failed to enter in successfully completed digital education class and pay required fee as ordered by the court in violation of the additional condition 18 of your probation order. Allegation number 5 alleges that you failed to provide verification of having auto ignition interlock system installed in your automobile in violation of additional condition number 19 of your probation order. Allegation number 6 alleges that you failed to report to the Liberty County Community Supervision and Corrections Department by mailing in a report or online for the months of September 2025, August 5th, 2025, for a drug screen as directed by the court in violation of condition 21 of the special amendment filed on December 23rd, 2025. Allegation number 7 alleges that you failed to report to the Jefferson County Community Supervision Correctional Department by mailing in a report online for the months of January 2025, March of 2025, September 25, as ordered by the court in violation of condition 21 of your special amendment filed December 23rd, 2025. Now, Mr. Denton, if the court finds that any one of these allegations are true, the court can assess punishment, in this case, up to 180 days in the Jefferson County Jail. Do you understand? Now, I have before, well, first of all, you have a right to have an attorney. In this case, I have before me a motion that is not a motion, but a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state that you like to waive your right to attorney and represent yourself? I also have another document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Denton, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Denton, you can have a seat. We'll have Mr. Maserati come out and talk to you.
Okay.
All right?
I think
All right, you need this. Okay. All right.
I'm waiting on Cornelia.
We don't.
Are they doing some paperwork on you?
Yes, please turn it.
It's already turned in?
No, I haven't received it.
Oh,
Okay, now, Ms. Bonsall, Attorney Wright Kemmler, will be submitting a letter of rep. I think that's what was said last month.
Well, that's what I mean. I thought it was, yeah, I did.
Yeah.
That's what I have to check.
Yeah, so we're gonna reset your, well, this time I'm just,
Put that out, yeah.
okay. That's what I'm kind of, well, this is 84 days up. So we're gonna reset it, we're gonna give you a standard reset to give Mr. Kimmel an opportunity to get his letter of rep in. And for him to, get with the district, get with you, get with the district attorney and, get an offer and discovery, and then when he comes back, he'll make an announcement. Okay, so we're gonna set it for an announcement give us a date. Standard.
May 27th.
Okay, this case will be reset to May 27th, 2026 for an announcement. Ms. Bonsall, you could get your reset. Once you get your resets, you're free to go. You have a blessed day. Mr. Kimmel, you're free to go and you have a blessed day. Okay. We're waiting on Jefferson County Court at law number 2 is back in session. The court is in session and calls number 25 CCCR 2166. Case is style of state of Texas versus Luis Eduardo Gomez. Mr. Gomez, is that your full name?
Yes.
Mr. Gomez, would you please raise your right hand? Mr. Gomez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gomez, you may put your hand down. How are you doing, Mr. Gomez? I'm doing fine. Thanks for asking, Mr. Gomez. You're representing your case by your attorney, Jason Nix. Mr. Nix, do you waive a record in Mr. Gomez's case?
I do, Your Honor.
Mr. Gomez, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Luis Eduardo Gomez, on or about November 10th of 2024, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Gomez, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Gomez, how do you plead? Guilty, not guilty, no contest? How do you plead? Guilty, not guilty, no contest?
It's guilty.
Guilty. Now, are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty? Okay. Now, Mr. Nix, you have to check box. It's a Class A misdemeanor.
Yes, sir.
Yeah, you could erase that one. Don't worry about it. I erase it for you.
Thank you.
Okay. Now, Mr. Gomez, I have before me on my computer tablet a document that is titled misdemeanor plea of mines, but also labeled as State's Exhibit Number 1. Do you recognize this document? Now, there's one box that's checked. This box that's checked states that this is a Class A misdemeanor. Ranging punishment for a Class A misdemeanor is a fine fine range from 0 days to 365 days, which is a year in the county jail. Or you could be given a fine that does not exceed $4,000, or you could be given both such fine. But do you understand that? Now, on page 2 of the same document, there's a set of initials, LG, on the line next to the box that check guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of the defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up the right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. And do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant? Mr. Gomez, before you signed and initial these documents, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Gomez, are you a citizen of the United States? State you like the office, States Exhibit Number 1?
Yes, Your Honor.
Any objections? No objections. States Exhibit Number 1 will be admitted. Mr. Nix, you've advised and counseled Mr. Gomez. Is there any evidence that he is currently mentally incompetent to stand trial?
Not at all.
And Mr. Gomez, your attorney, Mr. Nix, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes.
Mr. Gomez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
It'll be 90 days confinement in the county jail, probated for 1 year with a $500 fine, DWI standard conditions, and an interlock device.
Okay,
And that's correct, Your Honor.
okay. Okay, Mr. Let's see, add this up. What's the court cost in this case? How much?
377.
377.
Six.
Okay, Mr. Gamaz, the state is offering that you serve 90 days in Jefferson County Jail. However, you are not required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll be required to pay DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month. You now fee of $15 a month, reimbursement fee of $15, and you'll be required to pay Jefferson County DWI education an initial evaluation fee of $125 on the day of plea. Should a further evaluation be needed, you will be required to pay an additional additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay in this case, is $172 a month. Will you be able to pay the $172 each month?
Yes.
You will also be required to install an interlock device on any vehicle that you own or operate, be required to attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. You will not be required to perform any community service because community service in this case is waived. Is that correct?
Correct.
Okay. Now, Mr. Gamez, do you understand the state's offer? Do you think the state's offer in your case is fair and just? Do you accept the state's offer? Mr. Gamez, I'll follow the working agreement that you have entered into with the state. Mr. Gamez, just stand next to the bailiff at the end of that table, follow her direction. Once you finish following her direction, you'll be free to go and you have a blessed day. And Mr. Nix, you're free to go and you have a blessed day. What's that?
Okay.
Add up.
Okay, we got
And, the prosecutor was Maserati, right?
Yes, sir. All we're doing is reset for 2 weeks. If he gets this
Okay.
time, we're gonna dismiss it.
Okay, give us okay. We're gonna give you a 2-week reset. Once you get your reset, you'll be free to go.
Yes, sir.
Yes, it's a 2-week reset. And for him to, what, y'all have,
He's gonna pay off the remaining balance of his supervision fees and his community service.
okay. Okay,
Thanks, sir.
okay, just have a seat in that first chair. It's gonna be what? It's, May 13th. Okay, and make sure we'll make a note on that. He has to pay balance and complete. He's paying balance and community service, which is CSR, right?
Yes, sir.
CSR. Yeah, all caps, CSR. That's community service. All right. That'll be dismissed. And the next one, you said we had another one? Mr. Gilliam? Oh, Mr. Gilliam, we doing Jones?
Jones as well.
Okay, court is in session and cause numbers 24 CCCR 1440 and cause number 24 CCCR 2236. Both cases of South State of Texas versus Christopher Sean Jones. Mr. Jones, is that your full name?
Sean Keith Jones.
Okay. How are you doing, Mr. Jones?
Oh,
That's good, Mr. Jones. You're represented in your cases by your attorney, Marvin Probo. And Ms. Probo, what's your announcement in Mr. Jones' cases?
Mr. John, we requesting that we get a 60-day extension on this matter so that Mr. Jones will start provide his community service and also to pay some of his money.
Okay, so what's the plan is for him to perform community service and to pay fine? Is there a specific amount? that-
372 to get current.
So, okay, so he's gonna pay fine to get current. And he's going to do what? Community service,
Community services.
community service. And so if he does those things, what's the plan?
Well, he still has 3 felony charges that's pending.
Right, I mean, I remember signing this MTRP. Right?
yes.
Okay. So, I mean, if he just, what I'm trying to understand is, so he does his community service, he's paying his fine to get current. But I mean, he still has cases that's open.
I kind of need some help. My mom have died since 8 times a week, and she's been weak, been falling on.
Okay. Now, we can't, I don't know if there's some agency that you can talk to get that help that you need. But I guess what you alluding to is the fact that you probably need to be at home with your mom, right?
Yes,
But guess what? But you need to do this community service.
somebody need to be there with her.
Okay.
With somebody trying to be there with her, and she's
Okay.
hard-headed.
Well, let me tell you this here.
We're doing the analysis.
Okay, let me tell you this here. This is something, they don't have to make this agreement with you. Okay? Okay? So either you wanna agree to what they're saying, or if you don't wanna agree, I mean, if you don't, that's your choice.
I agree.
Okay?
I'm agreeing, I just saying I need help.
I understand. But you're gonna have to get someone to make some arrangements, with that. Okay? But I was wondering what was the game plan if he pays and get current and does his community service.
Oh, I would think continue until he completes the probation, Judge. He just got on it, I think, in.
Oh,
Yeah.
okay, I see what you're saying, just continue him on the probation. Okay. Okay. And
That's
so
what we have.
I
60
understand,
days give us a good.
okay, to see whether or not he's gonna be a man of his word. Okay. So we're gonna reset it for 60 days for you to get current on your fine fees and costs, and for you to perform all the community service. Is it all of his community? Well, how much community service does he have?
So what is it? 40.
Oh, 40? Oh, yeah, 2 months.
80. No,
80?
80.
Converted.
Oh, both, yeah, 40.
Yes.
But I thought they were running concurrency. I didn't have, there arose out
Oh.
the same set of facts, Judge.
Okay,
I didn't know if it was.
they are running concurrent.
If they're running concurrent,
If
then.
it doesn't, we don't have, it says concurrent.
No, you don't have to say if only if the court does not say consecutive, the law says it's concurrent.
Okay, all of our misdemeanor cases are running, unless it says concurrent, running on.
That's not, yeah,
We can.
Okay.
I'll talk to my supervisor.
Yeah, do that.
Back to the
Okay.
office.
okay.
See, I was on the, like I said, when they.
Yeah, I know, I just
was on the-
assumed that, yeah, because we always was telling them, even when they come up, that your community service is running concurrent, you know,
Cause we deal with when
Right.
there's a felony case.
right,
you
right.
know, If they on probation for a
Right.
felony.
Right.
You're running concurrent.
Yeah.
Cause we don't wanna have additional
Right.
costs, additional
Right,
fees.
right. Okay. So your case is gonna be reset 60 days. Give us a 60-day reset. Okay, she's gonna just have a seat. She's gonna give you a reset. Once you get your recess, you're free to go and you have a blessed day. You need to be here in person. Okay? You need to be here in person. Okay.
Well, here's the key. If they're
I guess my basically, I guess,
Pacemaker?
that's why I call it, my heart.
It's a heart, okay.
When my heart dies, it shocks and backs up.
He just,
He's had a heart attack.
Oh, wow. Okay, okay, okay. Oh, okay. Did you file anything?
I'm sorry.
You said something
No.
about a psychological.
Yeah, I will file for, no, I just found
I mean, cause I was thinking if we do a informal inquiry, we'll have to clear out the courtroom. You know. Might do that,
When did you get out? No, I'm sorry.
Yesterday.
he got a hospital yesterday. He got his-
yesterday?
Yes, from his heart attack. He had his, Thursday.
Wow, yeah.
Judge, can we just pass it? I need to just get a little more information. Can we pass them and we can do wisdom here?
Okay, Mr. Mejia? Okay, just have Mr. Woods to, he could go, wherever he feel comfortable. You want to sit in the gallery or jury box? Yeah, okay, that's fine. Mr. Mejia?
Right here.
He has one case.
Yes, two.
Yes.
One's being dismissed via cooperative.
Oh, okay. Announcement. Some ledge. Which one is, let me see, this is 46. Dutchess County Court at Law number 2 is back in session. The court is in session in 2 cases. They are called numbers 26 CCCR 0246 and cause number 26 CCCR 0247. Both cases are styled the state of Texas versus Edwin Mejia. Mr. Mejia, is that your full name?
Yes, sir.
Mr. Mejia, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mejia, you may put your hand down. How are you doing, Mr. Mejia? I'm doing fine, thanks for asking. Mr. Mejia, you're represented in your cases by your attorney, Attorney Jennifer DeLedge. And Ms. DeLedge, do you waive a record in Mr. Mejia's cases? Mr. Mejia, I have before me in cause number 26 CCCR 0246, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Edwin Mejia, on or about November 24th of 2025, while you were in Jefferson County, Texas, that you committed a Class A misdemeanor offense of resisting arrest, search, or transportation. Mr. Mejia, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Mejia, how did you plead guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir. Yes, sir.
And Mr. Mejia, I also have before me a document that is titled, Misdemeanor Plea Admonishment is also labeled as State's Exhibit number 1. Do you recognize this document?
What is that about?
State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant. Is this your signature? I mean, your initials, EM.
Yes, sir.
On the line that's titled no continuing, which means no contest. On page 3 of this document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, that's, oops. On the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case. You have no right of appeal. Do you understand that statement? Second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Mejia, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that you went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Mejia, are you a citizen of the United States?
Yes, sir.
State.
Tender State's Exhibit number
No
1.
objection.
No objection. State's Exhibit number 1 will be admitted. And Mr. Lodge, you've advised in counsel, Mr. Mejia, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Mejia, your attorney, Mr. Lodge, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Mr. Mejia, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And What is the agreement?
The agreement, John, is 180 days. However, that will be probated for a 9-month period of time, a $180 fine and 30 hours of community service, Judge. And in consideration of the plea, the state will dismiss the companion case pursuant to 12.45 of the Texas Penal Code, Judge, and that will be the evading matter. Is that correct, Mrs. Delay?
That is all correct, Mr. Williams.
Okay. Let's see, this is, so 180, what's the court cost?
277.
277. Like 9 months is. Let's, clear. And that's gonna be. Terrence fees, 425. It's gonna be divided by 8. Okay, Mr. Mejia, the state is offering that you serve 180 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 9 months. During the 9-month probationary period, you'll be required to pay a fine of $180 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your announcement fee, $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $425. Your total monthly installments, that is the total amount that you will be required to pay each month, is $197 a month. Will you be able to pay the $197 a month?
No, not really. I just started a job like a couple weeks ago, so and we started to catch up with our bills and stuff because I didn't have a job for a few months.
Oh. I have before me a document. He'll have to update this. That's titled Jefferson County Affidavit of Interest. Could you look at that document that I'm handing to your attorney? If there any changes need to be made, you can make it.
Yeah.
And I haven't even got a real check yet either.
Okay, I understand.
Right.
Ah.
All those expenses.
Yeah.
So that's correct. Sorry, Robert.
Okay, hold on a minute. Okay, let me do this. Oh, let's see. Let me do this. Let's see. Okay, let's see. Okay, Mr. Mejia, you reviewed the Jefferson County affidavit of indigence. Is everything on this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Mejia, the court is gonna find that you are indigent. Based on the finding of indigency, the court costs, well, the fine of $180 plus court costs of $277 will be converted to 37 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The attorney's fees in this case, $425 will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. You will be required to pay the probation fee in this case of $60 a month, plus your analysis fee of $15 a month. Your total monthly installments will be $84 a month.
It's $180.
$84 a month. Will you be able to pay
$100?
80? Yes, $84 a month.
Okay.
Will you be able to pay the $84 a month?
Yes, sir.
Okay, you will also be required to perform 30 hours of community service in addition to the 37 hours of community service that was converted from fine and court costs, which comes to a total of 67 hours of community service. Do you understand that?
Yes, sir.
And the state will be dismissing cause number 26 CCCR 0247 by way of a 1245 dismissal as to Article 1245 of the Texas Penal Code. Now, Mr. Mejia, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, Mr. Mejia, I'll follow the people are in agreement that you have entered into the state. Mr. Mejia, you're gonna have a seat, wait for your name to be called. Once your name is called, then you'll go to the window where your name is called. Okay? Now, Mr. Oh, you know,
Don't forget to do that phone one.
oh, here it is, right here.
We gotta get his.
Yeah. Okay, now.
Your Honor.
You're free to go.
Thank you, sir.
Okay. Should I say Ms. Delajay?
I'll stand here. I'll see y'all tomorrow.
If I can use your
Don't get too.
computer on. Yes, I need to do those dismissals, Judge. You give me a moment.
Oh, okay. Hold on a minute. Oh, wow.
I think I have like 3 dismissals.
Okay, here you go. Here you go. Here you go. And I'm gonna talk to, oh, yeah. Mr. Maserati and Mr.
Sure. It's gonna be reset.
Mr. Durian, what's his name? Okay. There it is. How do you pronounce your first name? Duncier? Okay. And Duncier Duran? How you doing, Mr. Duran? I'm doing fine, thanks for asking. Now, Mr. Duran, you had first of all, you are pro se, you represent yourself. You had an opportunity to talk to the prosecutor in this case. And it's my understanding that this case needs to be reset. Is that correct, State?
Yes, Your Honor.
And give them a standard reset.
Yes, Your Honor.
Okay. This is on the last person on the announcement docket, Doncier Duran. Okay, this case is reset to May 29th, 2026. Once you get your reset, Mr. Duran, you're free to go, and you have a blessed day. And going to be in recess. I think we're waiting on Mr. Williams to come back with his decision. Oh, that's right. He's gonna, he said that 3 cases they're disposing of.
He must put a yes on that too, huh?
Yeah, I think that's one of them. I think he's putting 3 on there. Yeah. Oh, was it added on?
Yeah, the one, I don't know about the other two.
The 2 is gonna be, I think, Miss Marvin's clients. Is that correct?
Oh,
That makes 3, right?
yeah,
The add-on in those 2.
yeah.
Okay. So I think this will just about finish with the. It's not gonna be long. Now, Mr. Woods, the state has dismissed both of your cases. Your attorney's gonna get a copy, you dismiss them. Once you get a copy, you're free to go and you have a blessed day. Okay, so you're free to go. And your attorney's gonna get a copy. You free to go?
Thank you. We get them all taken care of now.
Hmm?
Okay, starting to get blue.
Oh, yeah, you probably need to go, get some medical attention. All right? All right, you have a blessed day. All right, thanks for coming down here with your brother. All right, you have a blessed day as well. You got a good brother, you're taking care of him. He's taking care of you. That's a blessing. And this
Ms. Bravo,
court will be in recess for the
get
trial.
your dismissals, hold on, let me
You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 24 CCCR 1826. Case is styled the state of Texas versus Logan Odeberg. Let the record reflect that Mr. Odeberg is present in court with his attorney, Attorney Ralph Kimberly. State is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Andrew Hubel. Let the record reflect that the jury is now present and seated in the courtroom. And good afternoon, ladies and gentlemen. Ms. Nixon, if I'm not mistaken, you called one witness, and then that witness, after finished testifying, was excused. And so you'd like to call your next witness? Oh, Mr. Hubel?
Say we call Mendling Altamirano.
Okay, Mendling Altamirano. Ms. Altamirano, would you please come forward? Altamirano, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may put your hand down. You can take the witness stand and adjust the mic. Mr. Hubel, you may go forward.
May please storage bill. Good afternoon, Ms. Altamirano.
Good afternoon.
Can you state your full name and occupation for the record?
My name is Mendling Altamirano, and I am a forensic scientist
Okay. And where are you currently employed?
at the Jefferson County Regional Crime Lab.
How long have you been there?
Approximately 18 years.
And can you explain to me some of your duties in your current position?
Sure. I process physical evidence that's submitted by law enforcement for blood or ethanol, in addition to assisting police agencies in processing crime scenes.
And for your specific occupation, what is the educational background required?
I have a degree in natural science, specifically in biology.
And have you received any special training in the area of blood alcohol toxicology?
Yes,
And can you specify what that training was?
sure. I have received extensive internal and external training, including the Borkenstein course for highway safety, which is taught by the scientists in the field.
And do you belong to any professional organizations?
I do.
And what are they?
Southwestern Association of Forensic Scientists and the International Association for Chemical Testing.
Now, have you testified as an expert witness in the area of blood alcohol toxicology before?
Yes,
And on few or many occasions?
in between.
Okay. In this county?
Yes,
And are you licensed with the Texas Forensic Science Commission?
I am.
Are you a certified blood alcohol toxicologist?
I am licensed to perform blood alcohol analysis.
Okay. And what's that licensing process like?
I actually just got licensed today, renewed. So basically you have to renew every 2 years, but initially what you do is you have to be under an accredited lab and then take an examination, have several hours of training, and then from that point, you keep your license every 2 years.
You're my approach?
Yes, you may.
I'm showing you what's marked as Texas Exhibit number 4. Do you recognize it?
I do.
And how do you recognize it?
So it has my seal, my initials, the date that I sealed, in addition to the unique lab number we give it, an exhibit number and my initials again.
And can, just for the record, can you tell me what it is?
That is a blood kit.
And you recognize it as one that you analyzed based on the based on the identifying marks you just stated for the record?
Yes.
Okay. Now, I'm going to open what's marked as, Stacy's before. And this is marked as State's Exhibit 4B. Do you recognize it?
Yes,
And what is it?
that is a blood vial, and it also has the lab number.
That's not an evidence, Your Honor. She's here to testify about the vial. She mostly referred to it with the number. That's not evidence.
She's,
It's for,
objection overruled.
okay.
Okay, you may proceed.
So it has my lab number. I assigned this vial B and my initials.
So you recognize that as a tube that you analyze.
So that particular tube I did not analyze.
So then that would mean that this is State's Exhibit 4A. Do you recognize it?
I do.
Okay. And can you tell me what it is?
This is another blood vial with my lab number, my initials, and I assigned this vial the letter A.
And do you recognize this as a blood tube that you analyzed?
Yes.
At this point, State would turn to defense and offer State's Exhibit 4A and 4B.
In custody, first of all, Your Honor. Secondly, there's not sufficient indicia of reliability to indicate that it's been authenticated properly. Thus, I would inject that it's irrelevant at this time. They haven't indicated enough indicia of reliability to establish the relevance of this particular case.
Okay,
And then also chain of custody.
objection overruled. And states exhibits 4, 4A, and 4B are admitted.
Thank you, Ron. Do you recall the condition that those vials were received whenever you were in whenever you received them?
Yes.
Okay. And can you state what that condition was?
They were in a sealed condition.
Okay. And did you analyze the contents of the vial marked as marked into the State's Exhibit 4A?
Yes.
To determine its alcohol content?
I did.
All right. And when you performed that analysis, was the Jefferson County Regional Crime Lab and accredited lab?
Yes.
Now, what scientific process did you use to make that determination of the blood alcohol content?
So we use an instrumentation called Headspace GCFID, which stands for gas chromatography with flame ionization detectors, which is a mouthful. So basically, what you do is obtain a small sample of the vial from vial A. You put it in another glass vial that gets tightly sealed. That vial gets heated, and if a volatile is present, it will rise up as a gas. Then that gas will get transferred to another compartment that looks kind of like an oven. It goes through 2 coils, and then it separates the components and go through a detector. That detector then gets the signal, and it's displayed on a computer.
Okay. And when performing this test, the instruments that you used for that test, were they working properly?
Yes.
And you followed the protocol for using those devices to test for blood alcohol concentration.
Yes.
And when you completed that test, did you receive results?
I did.
And what were those results?
May I refer back to my notes, please?
Yes.
So those results were 0.135 plus or minus 0.010 grams of ethanol per 100 mLs.
And whenever you received those results from your testing, did you incorporate those results into a report?
I did.
May I approach your honor?
Yes, you may.
I'm showing you what's marked as State's Exhibit number 5. Do you recognize it?
I do.
Okay, and can you tell me what it is?
This is the report that I generated for this case.
All right. If you would take a moment to review it, make sure that it is in fact the same, and can you tell me whether or not there are any alterations?
No alterations.
State would turn to defense and offer, state side.
Yes, hearsay, your arm plus bolstering was.
Objection overruled. State's exhibit number 5 is admitted.
And as part of your job duties, are you familiar with the standard or intoxication whenever it comes to blood alcohol concentration?
What the legal limit is, or?
Yes.
Yes,
And what is that?
0.08,
And was the result in this test higher than 0.08?
yes,
So based on your training experience and the results of your analysis, did you form an opinion as to whether the defendant was intoxicated?
Your honor, it calls for speculation.
Can I finish the question?
I'm supposed to ask her opinion on whether he was intoxicated.
Well,
It calls for speculation.
At the time of testing.
Well, there would be other factors involved to form that opinion. This is speculation. Whether he was actually intoxicated based upon that test, you'd have to know other factors other than just the results of the test. When it was drawn, extrapolation, retroactive extrapolation, because it's not the time of the test, it's the time the motor vehicle is being operated. He's asking her to speculate based on a retrograde extrapolation, which is what they're asking. There's other factors that are involved.
And that was, and my question was at the time of testing, not at the time of.
Well, that's irrelevant. It's not what it is at the time of testing. It's what it is when he's operating the vehicle. That's what's called retrograde extrapolation, looking at what it was at the time of testing versus the time when he was operating the vehicle.
Okay, objection overruled. You may proceed.
So I'll repeat the question. Based on your training experience and the results of your analysis in this case, did you form an opinion as to whether the defendant was intoxicated at the time of testing?
yes.
And what is that opinion?
That anybody above 0.08 is considered intoxicated.
And the results of that test from the time of this testing, in this case, were they above 0.08?
Yes,
State best evidence.
Is intoxication at the time of testing relevant to the offense of DWI?
the time of testing, I don't know.
Is somebody operating a motor vehicle when the blood is drawn?
No, it's
Okay, do they have to be operating a motor vehicle while they're intoxicated?
at the time of driving, yes, they would have to.
So if they're intoxicated when the blood is drawn, they're not operating a motor vehicle, are they?
No, they're not.
So they wouldn't be driving while intoxicated at the time the blood is drawn, right?
At the time the blood is drawn, I couldn't say because I don't know.
If I represent you at the time the blood is drawn, they're not operating a motor vehicle.
Right,
Is it relevant to what it was when they're operating the motor vehicle intoxication?
I think you guys will have to determine whether it's relevant for you or not.
But when you're saying above 0.08, it's the time of testing that it's above 0.08, not at the time they were operating the motor vehicle.
That is correct.
Is it important the length of time that elapses between the operation of the motor vehicle and the time of the testing?
It depends on where you're going with this question, I think.
I'm just asking, is it relevant the length of time that elapses between the operation of the vehicle and when the when the blood's actually drawn?
I think it depends on where you're trying to say. So if you're trying to establish whether the person was intoxicated at the time of operating the vehicle, you do need a lot of factors in order to take that into consideration, especially time of luster. Now, if all I'm saying with my report was that at the time of testing, which occurred, I believe, an hour and a half after, The intoxication level was above 0.08.
You don't know when it occurred, do you? You weren't there. You don't know it was an hour and a half, 2 hours, 3. You don't know how long it was, right?
The only thing I know is when the time of stop was and the time of draw.
You don't know that. You weren't there. You know
That's
that.
correct.
You have knowledge of that. You were there. You know when the
Well-
stop occurred, right?
So,
Do you or do you not know when the stop occurred? Were you there?
so based on
Hey,
the,
ma'am, I'm asking you a question. Do you know when the stop occurred? Were you there?
sir, I'm trying to answer the
Were you there
question.
when the stop occurred?
No, but based on the report that I
Objection,
have.
objection, non-responsive. You weren't there when the
Oh,
stop occurred.
Oh,
right?
well, Mr. Kimmler, let's not be argumentative. Give the witnesses an opportunity to answer the question.
Would object, it's non-responsive.
Okay, objection, your objection is sustained, but you still have to give the witness an opportunity to answer the question.
Okay, I'll endeavor to do that. You
Okay.
weren't there when the stop occurred, is that right?
No, I was not physically there.
So you don't know when it occurred. You don't have personal knowledge. You didn't see it, right?
I didn't see it.
You have knowledge or belief based upon what you may have read in the report, is that right?
The submission form.
The submission.
Correct.
My question to you is it a relevant factor in determining intoxication at the time the vehicle was operating? You're trying to extrapolate backwards what that was, what the alcohol content was, the length of time between the operation of the vehicle and the time that the blood was actually drawn.
Mhm.
Is that relevant? The length of time that elapses between the operation of the vehicle and when the blood is drawn.
Only if you're trying to establish what the concentration was at the time of driving.
Is that what's important in a driving while intoxication case? What the intoxication was, what the level of alcohol was when the vehicle was being operated? Isn't that the relevant question?
Okay, no,
It's driving while intoxicated, right?
correct?
So the 0.08 being above a 0.08 or a 0.08 or above, that has to be while you're operating the vehicle, right?
That's according to what it says, yes.
Right?
That's what it says.
The law.
Is that what you're telling me? It says, that's my understanding, but I'm also not very in detail with the law. My aspect is more on the science part. So if you consider that important.
Well,
then
if I represent you that the offense is operating a vehicle while intoxicated, right?
Okay.
We can agree to that, right?
Sure.
So it's not intoxicated an hour and a half later. That's important, right?
Like I said, it's depending on what you're trying to establish.
I'm asking you a question, all right? Is it important what intoxication, what the level was an hour and a half later in and of itself to establish intoxication while you're operating the vehicle?
If the question is whether it was intoxicated at the time of draw, and if that's important, and that's what you want to know, then yes.
I'm asking you about the time of operating the vehicle, all right? What the time the blood draw occurred while he was not operating a motor vehicle. Can we agree to that?
Yes,
And that happened sometime after he was operating the motor,
that's correct.
right?
Correct.
So if it's a point above a 0.08 or above at the time after he's operating the vehicle,
Mhm.
that's not while he was operating the vehicle, right?
That's correct.
So your results relate to a time that is after he was operating the vehicle, correct?
My results are linked to the time of testing.
Of the blood draw.
Yes, testing of the blood draw.
The blood draw occurred after he was operating the vehicle.
Yes,
The length of time that elapsed from the operation of the vehicle to the blood draw, whether it's an hour, 2 hours, 3 hours, the next day,
Mhm.
that's relevant, right?
Like I said, it depends on what you're trying to establish.
I'm trying to establish,
Your Honor, I'm objecting to ask and answer at this point. If we keep going with the same, like, the same flow of
And I
questions,
would
we're not
object.
getting anywhere.
Hold on,
I
let me-
object that I'm not getting a clear answer to this, Your Honor, that it's non-responsive.
Okay, objection sustained.
The blood draw is after the operation of the vehicle.
Yes,
Your results are for a time period when he was not operating the motor vehicle, correct?
that's correct.
So when you testify regarding intoxication, you would be testifying about a time that when he was not operating the vehicle, correct?
That's correct.
You don't know what he was. You're familiar with the term retrograde extrapolation?
I am.
You do not have sufficient information to engage in retrograde extrapolation in this case, do you?
That's not correct.
In other words, when I say that, you can't say, based on the available facts you have,
Mhm.
whether he was a 0.08 or above at the time he was operating the vehicle. to engage in the retrograde extrapolation.
That's correct. I cannot say at the time of driving the vehicle.
Now, as far as the way the blood draw occurred, that's important, isn't it? Or
Sure.
do you know?
I don't know anything about the blood draw.
I mean, I'm talking about the requirements, where the blood draw is supposed to occur.
I don't know anything about the requirements.
Okay, so for instance, if somebody used an alcohol swab to clear the site before they drew blood, will that affect the result as opposed to iodine?
Actually, there's been several studies in which they purposely used hand sanitizer or alcohol in order to see whether that appeared in a blood draw. And they found that you have to purposely inoculate the actual vial in order for you to make a difference.
According to the statute, are they supposed to use non-alcohol antiseptic, do you know? Or not?
I'm sorry, can you repeat?
According to the statute, the blood draw statute, are they supposed to use non-alcohol antiseptic or not, do you know?
I believe they recommend iodine.
You don't know how that occurred in this case, right? Because you weren't there, okay? What about how the sample is handled or stored prior to it being shipped to the lab for inspection?
Okay,
What is supposed to occur there? Is it supposed to be refrigerated?
so that is the recommendation.
What if it's not refrigerated?
So the length of time, if it's a room temperature, that would be also acceptable.
Do you know when the test kit arrived at the crime lab?
I do know when it arrived.
When did it arrive? You remember, you need to refresh your recollection.
I need to refresh my
Don't
recollection.
be a refresher.
So the kit was submitted on March 14th.
Where was it stored?
Once it was submitted, it got stored in a refrigerator,
You're sure?
100%.
Personal knowledge. You remember going in there, you're just going by pattern and practice.
So I work a lot of cases, and I think what you're getting at is if I remember this particular case, right? So I would say, no, I don't remember working this particular case. However, I keep extensive notes in order to answer questions like this.
So it's your pattern and practice to store it in a refrigerated environment, but you're not prepared to testify that that's exactly occurred because you don't have personal knowledge of this case. Is that right?
My answer to you would be
Why do you keep looking at the jury when you answer my questions, man?
because I'm here for the jury.
You're trying to, when I'm asking you questions, is there a particular reason you keep looking at the?
Yes, because
Why
I'm
is
here,
that?
because the jury is what is going to determine your case.
Were you trying to do that? Did somebody tell you to do that? Or you do that on your own?
If you would like, you can stand right here with
I'm
the
asking
jury.
you, were you told to do that, or is this something you came up with on your own?
No, this is something that I've always done.
Were you told to do that?
By whom?
By anybody? Were you told to do that?
No, it's
Okay.
something that we've always done.
So how do you know that it was refrigerated? You don't, do you?
I do know that it was refrigerated because I can pull the chain of custody and show you exactly when it went in and at what time it went in.
By somebody else, not you, is that right?
By the person that takes in the evidence, yes.
How long did it stay in the lab before it's in?
So it was submitted in March and I actually assigned it to myself. I believe it was in May.
So you didn't get around to it till May?
That's correct.
What day in March was it submitted?
It was submitted March 14.
What day was it tested?
It was May 16th.
So 2 months it sat in the lab?
That's correct.
And there's no degradation that occurred in that time period of the sample?
I'm sorry, can you
There's
repeat?
no degradation to the sample that occurred during that 2-month period?
No,
How are you sure?
I'm sure.
Yeah, you're a forensic scientist. What's the chemical process to ensure that an organic sample doesn't decay over a 2-month period of time before it's tested? And then the integrity of the test is preserved during the 2-month period?
So the vials come equipped, the gut vials come equipped with a preservative and an anticoagulant. Once I actually look at the vial, I turn it upside down and I make sure that there are no clots or anything that looks different in order to move forward.
Did you do that this occasion? You have personal knowledge? Remember doing that on this occasion or not?
So I don't remember the case on how it happened. However, if that was the case, I would have added that to my notes.
What's the importance of mixing the What's the anticoagulant? What's the chemical compound? What's the name of it? Do you know?
Yes, potassium oxalate.
Potassium oxalate. What's the important mixing, thoroughly mixing the potassium oxalate at the time the draw is made originally to mix it to ensure that it's mixed
To
thoroughly?
prevent, clotting.
It is important to make sure it's mixed thoroughly at the time that the blood is drawn.
I would say so, yeah.
Would you agree that there should be testimony about that in court to assure that there was a proper mixing of the anticoagulant in the blood sample at the time it was drawn?
I
Do you
actually
expect that?
can't answer that question.
Is that an important fact that it was mixed thoroughly at the time the blood was drawn?
It is important.
Because if it's not, what could occur? The integrity can be compromised of the sample, is that right?
Not necessarily.
Well, why is it important then?
It's important because, with that, you're also mixing the sodium chloride, which is your preservative. So, a sample that's mixed well, would definitely have a less chance of getting,
To be compromised, is that right?
any microbial growth or any, or any clotting. But then,
Oh, go ahead, sorry.
no, I'm listening.
The microbial growth, I guess you're referring to fermentation and alcohol, or from alcohol, could be increased from fermentation for microbial growth, is that what you're referring to?
What I'm referring to is possible. However, the fact that it's been refrigerated, and one of the reasons that we refrigerate is to maintain that from happening.
What about prior to being sent to you, is it, or did it be refrigerated then? Do you know if it was or not, before it was sent to you?
I have no clue what happened before it was sent to you.
So that's important too, right, whether it was refrigerated before you received it?
As I mentioned earlier, if it's a room temperature, it's also acceptable.
For the 2 month period or just before it was sent? If it laid out for 2 months at room temperature, that wouldn't compromise the integrity of the sample?
So what I'm looking at right now is,
Ma'am, if it was set out for 2 months without being refrigerated, would that compromise the integrity of the sample?
no,
Okay, so why do you refrigerate?
because that's just our protocol and our policy.
So it's really not important whether it's refrigerated or not?
The
If it's
point
not, to leave it out, if it's not gonna affect it, why refrigerate?
The point of refrigeration is also, to prevent ethanol loss.
All right, so when you tested this, what was the procedure? You used the gas chromatograph mass spectrometer, or is there some other device that you used?
So it's no, it's a Headspace GCFID, so it's a little different than the GCMS.
What's the difference between that and the gas chromatograph?
So with our instrumentation, the detectors are different. We're using something called flame ionization detectors. And we're not sampling what we're sampling is the vapor that creates above and not the actual liquid.
So the process is the blood is superheated, is that correct?
It's heated at a temperature where,
What temperature?
okay, so, it's heated, once it enters into the oven, it's 40 degrees Celsius.
Which is how much Fahrenheit?
Okay, so you would have to add, if I can.
Hmm.
32.
32, all right.
So it would be, let's say, the Celsius times 1.8 plus the 32. That would be 104 Celsius.
So that-
Fahrenheit.
104 Fahrenheit.
Mhm.
So it's heated to 104 Fahrenheit, and then there's vapor off of the blood, is that right?
Right, yes,
Is it ionized or not?
at that point.
The vapor, is it ionized?
Not at that point.
Okay, what happens to the vapor after it evaporates off of the blood, or is evaporated?
So the vapor gets transferred by something called transfer line into the next part, which is the GC, which is the gas chromatograph.
And that's what it's ionized, and the spectrum is applied to it, the light, infrared light or not?
No, so what happens is it moves through the columns, or coils, we have two, and it separates out. Once it goes through the flame ionization detector, that's when it gets ionized, and then an electrical charge from the ions get created, and that's what the computer actually reads.
When was the last time that instrument was inspected prior to this test occurring?
So the instrumentation we do preventative maintenance annually. However, anytime we run a batch, we calibrate the instrumentation and run multiple quality controls to ensure that the instrumentation is actually working properly.
My question is, when was the last time the machine calibrated prior to this test?
Calibrated,
Well, inspected and then calibrated also,
So-
serviced and then calibrated.
okay, so this was done in May, and usually our preventative maintenance is due, I think, in November. So the last time will be November twenty
I
twenty-three.
asked you when it usually happened, ask when it happened, not when it usually happens. When did it happen?
I don't know the exact date,
You
I
don't
just know the
know.
month.
The answer is you don't know.
No, the answer, well, the exact date, no, I know
That was my
the
question.
month,
When did it happen? Do you know or not?
only the month in the year.
And you were there when it happened, or you're talking about some sort of documentation when it usually occurs?
No, I'm usually there.
Is your answer based upon what usually occurs, or is it based on personal knowledge?
It, based on both.
Well, so you have personal knowledge of when it was serviced, you saw it, you were there, you have personal knowledge of it.
Most of the time I'm there. I'm
This
not,
time, were you there this time?
so in November, I'm not sure if I was there or if it was another person from my section, but someone that's experienced in the section is usually there.
So you can't answer the question. It's just what usually happens, right?
What
There's a difference
exactly?
between what usually happens, what happens routinely, what you usually do versus what you have knowledge of and what you actually saw, right?
Okay,
So you can't testify based on personal knowledge when the machine was serviced, is that correct?
not a personal knowledge.
Okay. Did it appear to be operating accurately when you used it on this occasion?
Yes,
And did you do anything? Do you have personal knowledge or remember when any kind of protocols that you went to prior to the testing to assure accuracy on the test?
as I said, I maintain good records, so as me personally knowing this one particular case, no. However, there are records here that indicate that the actual instrument was working properly.
Did you do any of the protocols prior to testing this sample to assure that the machine was working accurately? What protocols did you use on this particular occasion to assure the accurate function of this?
Okay, so what we do is, we,
No, you, not we, you, what did you do?
okay, what I do is I
What did you
calibrate.
do? What did you do?
Okay, I'm moving forward to that. So what I do is, I usually calibrate the instrumentation using 6 known ethanol concentrations.
Objection non-responsive, I asked what you did, not what you usually do.
Objection sustained.
What did you do? Not what you usually do.
Okay,
What did you?
what I do
What you
is,
did?
what I did and what I do is, I run 6 known ethanol concentrations, and I use that as reference for the unknown samples. Right after that, I run several quality controls, and I also run controls in between each case.
And you saying you did that on this particular case, you have recollection of doing it, right?
As I said, I have notes and
You
of
have a
doing this.
recollection of doing it or not?
No,
You don't remember?
no,
You don't remember if you did it or
not one particular case, no.
not? Right. So it goes into different tubes, the ionized vapor, am I correct in understanding that or not?
No.
How does it, where does the vapor, the ionized vapor go before the,
It goes through a detector, 2 detectors. So at the end, so we have 2 detectors, 1 for each column. And the samples move up, and that's where they go.
and then that's where, what type of light is applied to them? Is that the type of, is a spectroscopic analysis or what's the analysis?
It's ionization, it's an electrical current. There's no
So
light.
there's a resistance, that's how you just calculate based on the resistance, or how is it calculated?
How is the concentration calculated?
Yeah,
It's based on the area of the peak from the internal standard and what the ethanol peak, also the area from the ethanol standard and the area from the internal standard peak and the area from the ethanol standard peak are used in order to.
how are you
calculate.
determining the peak? It's not a spectroscopic analysis. How's the peak determined? The electrical resistance or the ionization?
Is the term based on the quantitation that it's reading or based on the amount that's being processed at that
The
time?
quantitation based upon what fact, what empirical fact is the quantitation based upon? What scientific fact? Is it the resistance? What is it? The spectroscopic, you shine infrared light.
Chromatography.
So there's light applied to this or not?
No,
What type, how are you obtaining the chromatography?
because once you put the mixture, it goes through the columns and that mixture gets separated. Once it gets separated, they come out to the detector and the detector ionizes and creates an electrical charge that the computer is able to read.
So this is just based on what a computer is saying, is that right?
It's based on a method.
What's the software? Are you familiar with the software that the computer runs?
So I know the software, but I don't know any more information aside from the software.
What do you know about the software? Who developed the software?
It's Chem Station, and this is an acceptable software that's used
Acceptable by,
by the forensic science
you know
community.
anything about the software?
Not particularly.
Isn't it true that's proprietary software and no one knows anything about it? Is it proprietary software?
I don't know.
You're not familiar with whether it's proprietary. Who runs a check on the software to make sure that's functioning accurately?
Usually we do.
You run your own diagnostic on it?
I use the software and, but no, I don't maintain the software. I don't know.
Who
I don't-
maintains the software?
No one really.
The proprietor, right? The person who provided the software, the company that provided the software, is that right?
So they provided and uploaded into, yes, it uploaded into our computers, yes.
And they're the ones that do the diagnostics on the software, is that right?
None is, I don't know actually.
If you answer, you don't know, you don't know.
Yeah, I don't
When
know.
was the last time diagnostics were run on the software?
It was done last year because it was upgraded.
What year, what month?
Again, I don't remember exactly.
So it was updated,
Upgraded.
upgraded, so there was something that needed to be upgraded from its prior incarnation, is that right? Or its prior iteration?
It was more just for ease or just additional information that could be printed on our paperwork.
You know, if the upgrade occurred prior or post the test that we're talking
I'm
about?
sorry, I didn't understand what you just
The
said.
upgrade, did it occur before the test that we're referencing today, or was the upgrade after the test?
After.
So we can agree then that this test that we're referring to today occurred prior to the upgrade on the software, prior to the diagnostic of the software?
Prior to the upgrade of the software.
Passwords.
Okay. Mr. Hill?
So in regards to extrapolation,
Mhm.
is it generally required for you to do that analysis that you know, approximately when the defendant last drank?
The only time I am required is if they request, if someone requests.
Yes, but if someone were to make a request,
Mhm.
is it important or is it vital to know approximately the last time the defendant drank?
Yes, that is very vital.
Okay, and without that information, if it can't be provided, would you not be able to complete an extrapolation analysis?
It would be meaningless. No.
Um. But based on your prior testimony, you can say for certain what the defendant's blood alcohol concentration was at the time of blood draw.
At the time of testing, yes. Okay.
Now, is your testimony that you take extensive notes, correct?
That's correct.
Right. And do you take those notes prior to your analysis?
Yes, so basically, the way it happens is, I evaluate the files and make sure that all the information on the files matches the submission form. After that, I go ahead and sample, and every result that's coming out, I'm checking to make sure that it's actually passing. So all the controls have to pass in order for me to move forward with any type of analysis.
And the notes that you make, would they contain any type of inconsistencies, issues, or other various forms of problems that you would see in a particular sample?
So I run batches, which means that I run, let's say, 20 samples at a time. So for this one particular case, no.
But if you did notice any, inconsistencies or issues with the sample, you would note them.
Absolutely.
Okay. And that would take place regardless of what part of the process that, you notice it.
That's correct. And our cases are reviewed 100% by secondly qualified.
That's a non-response.
Repeat your question.
Oh, that, and is there any type of, quality assurance that goes into your notes or analysis?
In my what, I'm sorry?
Your notes or analysis?
Yes, so we follow our quality procedures.
Okay, and is that, peer reviewed?
Absolutely.
Do you have any notes regarding any degradation that occurred in this case?
No.
During Mr. Killer's questioning, you talked about, an issue, called ethanol loss. What does that mean?
ethanol loss.
Yes.
It just means that, the ethanol is basically lowering the concentration.
Okay. So would that process also, by correlation, decrease the BAC, the blood alcohol concentration of a given sample?
With ethanol loss, yes.
No. And whenever you perform, these tests on blood samples, you make sure that the equipment operates accurately, correct?
Yes.
Is that correct?
Yes.
And as you testified, there are multiple quality controls that you use prior.
Yes.
This is your standard practice.
Yes.
No further questions.
Move for you know.
Okay, may this witness be excused?
No,
Yes,
sir.
sir.
Okay. Salter Morano, you're excused. You can step down and you have a blessed day.
You as well, sir.
Thank you. Thank you can call your next witness
This time stay with rest.
and defense.
Your Honor, we have a motion to present that. Just
Okay, ladies and gentlemen, we have to take a matter outside of your hearing. So we're gonna ask that you please stand and exit the courtroom. Okay,
At this time, the defense moves for an instructed verdict of not guilty based upon the failure of the state to produce legally and factually sufficient evidence for the state's continued presented to the jury.
All right. Hold on now, hold on. You got the red. I don't want to stop going.
You may be seated. Hold on. Jefferson County Court, Law number 2 is back in session. The court is in session and calls number 24 CCCR 1826, case style of state of Texas versus Logan Oderberg. Let the record reflect that Mr. Oderberg is present with his attorney, Attorney Ralph Kimler. State is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Andrew Hubel. Let the record also reflect that the jury is now present and seated in the courtroom. And the state has rested, and Mr. Kimler.
Defense rest, Your Honor.
Okay, so both the state and the defense has rested their cases. Ladies and gentlemen of the jury, the court has to prepare and submit to you a charge. We will have prior to that being done, we will have a charge conference in here with the attorneys. And we're gonna ask that you step outside so that we can prepare the charge and have the charge conference. Okay? So you can, everyone please stand as the jury exit the courtroom. Okay? Yes.
Okay, gotcha.
Go to be in recess.
I can speak around.
You may be seated. Let the record reflect that the court is back in session in cause number 24-CCCR 186. Case is style of state of Texas versus Logan Odelbert. Let the record reflect that Mr. Odelbert is present in court with his attorney, Attorney Ralph Kilmer. State is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon and Attorney Andrew Hubel. Let the record reflect that the jury is now present and seated in the courtroom. At this time, ladies and gentlemen, I will read to you the court's charge. Members of the jury, the defendant, Logan Odelbert, stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have occurred on or about the 7th day of March 2024 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of his physical or normal faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances into the body. The term intoxicated also means having an alcohol concentration level of 0.08 or more. Alcohol concentration means the number of grams of alcohol per 100 milliliters of blood. A public place means any place to which the public or a substantial group of the public has access and includes but is not limited to streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. The state has offered testimony by an expert if scientific, technical, or other specialized knowledge will assist the tier of fact to understand the evidence or to determine fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. Now, if you find from the evidence beyond a reasonable doubt that on or about the 7th day of March 2024 in Jefferson County, Texas, the defendant, Logan Odelbert, was intoxicated and while so intoxicated did drive or operate a motor vehicle in a public place in Jefferson County, Texas, then you will find the defendant guilty. Unless you so find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence. and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proved, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of this charge, or the page that is attached to the charge, is called the verdict form. You know that there is divided into two parts. You have a top and a bottom. In the middle, it says "or." Now, if your verdict, if you state that we, the jury, find the defendant not guilty as charged in the information of driving while intoxicated, if that is your verdict, your foreperson will sign on this top line. It says, "or we, the jury, find the defendant guilty as charged in the information of driving while intoxicated." If that is your verdict, then your foreperson will sign on the bottom line. Okay. Does everyone understand? Okay. Mr. Kimler and Ms. Nixon, the court is going to give everyone the agreed upon time of 25 minutes for closing. State you have the right to open and close during your closing statement. And Ms. Nixon, I'll be keeping the time. You like to proceed?
State waives the right to open, or reserves the right to close.
Okay, you're gonna waive your opening, okay. And so, Mr. Kimler, you may proceed.
Yeah, sure. I'm just gonna try to limit it to 15, so if you.
Okay.
I hit 10, I'll try to.
Okay, I will.
I think honestly, jurors probably tend to lose interest after about 10 minutes, but say brief. It's not a long case, there's not a lot of testimony to recall. But it's not an important case, because it's a class A mission. Financial side of the issue, that you have to consider, if they have a conviction, that'll be determined by the judge, but that is the punishment, range up to a year in the county jail. I always like to start by quoting, where the judge lays off the instructions here in the last section, section 8 here. At the last sentence where in returning the verdict, it's your responsibility to make certain that justice is done in this case. I would just simply suggest to you that the obligation that each of you have to see that justice is done in the case is an individual responsibility. What I mean by that is not some sort of collective responsibility imposed on a group of people to return a verdict. You don't have to return a verdict either guilty or not guilty. Yeah. What I mean by that is you go back into the jury room and after good faith deliberations, you can't reach a verdict. That's what you call a hung jury. That's not a failure on the part of the jury. You just have to advise the bailiff in writing that you can't reach an agreement. It just means that there will be a mistrial in the case will be perhaps tried again. I would suggest to you that the only failure to see that justice is done is that if one or more of you were to surrender what you think is the appropriate verdict, either guilty or not guilty, that if you give that up, but you believe the correct outcome to be simply to return a unanimous decision, that would be an abdication of your duty to see the justice. Not required. You can't agree, and that's just the way it is. So, in looking at this case, you'll notice, or looking at the instructions, you'll notice what's not in here. And that's, as I said in word hour, that's the definition of what proof beyond a reasonable doubt is. The judge tells you what it's not. He tells you that it's not proof beyond all possible doubt, but it's proof beyond a reasonable doubt. And it's up to each one of you to apply that standard and give it what weight that you can and make it as difficult or easy as a burden as you can. If you think it's appropriate, and you could have 6 different opinions back there about the level of proof that's required to exclude reasonable doubt, and none of you would be wrong, because it's up to each individual. I would simply suggest to you that the board that because what we're talking about is if you say that the state has eliminated every reasonable doubt, then it becomes a question of punishment and potentially incarceration. And it's how high of a burden should it be before a citizen, any citizen from this community should be deprived of their freedom. And of course, it happens every day across this country that level of freedom is obtained by the state, and people are incarcerated all the time, so it's not an impossible burden. But it doesn't mean it's not a serious, it should be a high burden before that decision is made, somebody can potentially lose their freedom. Potentially you can start the sanction probation at a position that frames or contextualizes what proof beyond a reasonable doubt is. Having said that, once you go back and establish in your mind the level of proof, what proof beyond a reasonable doubt is, then examine the evidence and in the context of the evidence, what's required for the state to prove. In this case, it's relatively simple. Rodenberg was operating a motor vehicle. I think they established that he was operating a motor vehicle. You've seen get out of the vehicle, see the video from the dash cam of the vehicle driving. So he was operating a vehicle. So obviously you can see that. So then it becomes, at the time he was operating the vehicle, was he intoxicated? That's the real question. Was he intoxicated? And the judge has defined intoxication to mean, in the first sense, not to have the normal use of his physical or mental faculties. So that's one way that the state can establish intoxication, that he doesn't have the normal use of his mental or physical faculties because of alcohol. There's been no allegation of drugs or controlled substances or alcohol. So what is his normal mental state, his normal mental faculties? Has there been any evidence what he normally is? Has there been any evidence that when he performs a standardized field sobriety test, that he's not exhibiting his normal physical function, or his normal mental function? Certainly, you would look at the physical, there's not so much evidence about his mental function, but looking at the video when he's performing the test, has there been evidence that that's not his normal physical function, that that's not a normal for him, the way he did the 9-step one leg example? So that you'll be able to say, yes, he doesn't have the normal use of his physical faculties because of alcohol, else therefore he would be intoxicated. I would suggest to you that there's no evidence of that. There's no evidence that he didn't lack the normal use of his physical faculties. You don't know what normal is for, they didn't establish that. So since there's no evidence of it, then you can eliminate that grounds for to say that he was intoxicated. He had, obviously from the video, what appears to be the normal use of his physical faculties. There's no contraindication that that wasn't normal for him, the way that he walked the 9 steps or did the one-leg stand. So there's at least reasonable doubt that he did not possess the normal use of his physical faculties. And the other way that you will be able to find intoxication is through the blood test. Now, obviously, with the blood test, the 0.08 requiring is when they operate the motor vehicle, not an hour and a half, 2 hours, 3 hours, or however long it was after he operated the vehicle that the blood was taken. The indication that you have from the state's evidence is that if you believe that it was an hour and a half, it was only an hour and a half from the time he operated the vehicle to the time the blood was drawn. At the time the blood was drawn, an hour and a half later, perhaps longer, that's what the result was, if you believe the test was accurate, not when he was operating. The state hasn't provided you any evidence at all as far as what whether the 0.08 was, or the 0.13 above the 0.08 was, whether that was at the time he was operating the vehicle. That's what's important. That's what I was going over with the lab analyst is what's called retrograde extrapolation. You don't have any evidence before you that you could go back and say if it was a 0.13 at the time the blood was drawn, what would that mean when he was operating the vehicle? Was it above a 0.08? Can you say that he was a 0.08 or above at the time he was operating the vehicle based upon a lab result of a 0.13 an hour and a half after he was operating the vehicle? That evidence isn't there. You don't know what he was at the time he was operating the vehicle. There's at least reasonable doubt that he was a 0.08 or above at the time he was operating the vehicle. I would say there's no evidence of it. And again, if you look at the record, you can ask for testimony. You can be specific enough to testimony from the lab analyst regarding what his blood alcohol was at the time he was operating the vehicle. I think you'll see she didn't testify to that. You don't know what it was when he was operating the vehicle. There's no evidence of it. There could have been evidence of it, but you don't have it before you. It's the state's burden to provide you that evidence. And I will say there's no evidence what he was, blood alcohol content, what he was when he was operating the vehicle. The 0.13, remember, I said by their testimony, an hour and a half. I would suggest it's probably longer than that, but an hour and a half after he was operating the vehicle. When we talked to you about the blood test, remember, those results pertain to an event that occurred an hour and a half after he was operating the vehicle, not while he was operating. So there's at least reasonable doubt on that part, whether he was intoxicated. And again, looking at the blood test, you can extensively cross-examine the lab analyst as far as how the test occurs, the integrity of the blood draw, how the blood was maintained. And again, there's no evidence really from the officer that stored and transported the blood sample to the lab, that it was maintained with proper integrity, how that chain of custody occurred. Again, all these are things that the state's required to prove. Anytime they make the charge against somebody of a criminal offense, it's up to them to provide the evidence to people from the community, the jury, to justify conviction and punishment. I would suggest to you in this particular case, they've fallen short in that regard. There is reasonable doubt here for the reasons that I've argued to you, and that the proper verdict here is not.
Good. Ms. Nixon?
Thank you. Good afternoon. Justice is what we actually want all around. Everyone that's here today is here to seek justice for the defendant and for the state and for our community.
as Mr. Kilmer touched on, it is Kilmer, right?
Yes, ma'am.
I always say it, so I don't know how to say Kilmer. But permit is Mr. Kilmer, Himmler said, Killer said, the reasonable doubt, we can't define for you. It's all gonna be defined by yourself for this case and for yourself. And what it is, your common sense, your reasonable to read, your logical. Unfortunately, I'm losing my logic to read, I'm not using logic. But you're using your ability to reason. You're using your common sense. You're using your day-to-day life and your education, your background, making decisions for yourself and for this case. Just for as a correction, this is a class B misdemeanor. It's not a class A misdemeanor. So the maximum sentence for this would be 6 months in jail or probation. As far as the sorry. I meant to put something on over here.
Oh.
To remind you of the elements that the state has to prove. Okay, and the evidence elements that we brought to you today and yesterday were body worn camera evidence, dash camera evidence, testimony from Officer Corey James, and testimony from the Jefferson County Regional Laboratory forensic scientist, Memline Morano. Okay, so the evidence we brought you, there was a traffic stop that occurred in Port Arthur, Texas on March 7th, 2024. The elements we have to prove is in Jefferson County, Texas, the defendant Logan Odebert on or about March 7th, 2024, operated a motor vehicle in a public place while said defendant was intoxicated. As I was talking about, it all started with a traffic stop that was made on March 7th, 2024. During the traffic stop, the officer saw evidence of intoxication, red glassy eyes, a strong smell of alcohol coming from the individual, and slurred speech patterns. From that, he went to an investigation for DWI, from the traffic stop to the DWI. Mr. Odebert was identified by Officer James whenever we report as the person who was driving that motor vehicle that night of the traffic stop. And the traffic stop was taking place on public street after Officer James had followed him on Beltway Drive, Stillwell Boulevard, and 17th Street, which are all public places, public street that he'll drive on. And motor vehicle, he was driving a Hyundai van. It's definitely a motor vehicle. Officer James verified for us it was a motor vehicle. And the defendant, as far as the last, so we've done the defendant, Logan Odebert. We have Jefferson County, Texas, because those 3 streets are located in Port Arthur, Texas, which is in Jefferson County, Texas. On or about March 7th, 2024, was the day of the traffic stop in this incident. It operated a motor vehicle, the Hyundai van, in a public place. The 3 streets are public property, public streets that we can drive on. And the last one we have to prove is intoxicated. So there are 3 definitions of intoxication. I'm going to remind you those. Intoxication is legally defined, not having normal use of mental faculties, or physical faculties, or the alcohol concentration of 0.08. These are all or. We only have to prove 1 to prove intoxication. I believe the state has proven all 3. The state has shown you, we've given you testimony, and we've shown you videos that show several signs and symptoms intoxication, the red glassy eyes was from Officer James, strong smell of alcohol, slurred incoherent speech, he had balance issues in his SFSTs, swaying during the SFPs, and he had a blood alcohol level of 0.135. So if you remember, during the SFSTs, with the HGN1, Officer James said that the stimulus was, you have to look at the stimulus without moving your head. But you saw in the recordings, and as from Officer James, the defendant moved his head with the stimulus. He also noticed that he had nystagmus, which is the little twitching in the eye, on his right eye, before 45 degrees, which is, he said, was a symptom of alcohol use to the system. The next test that he did was a walk and turn. Walk and turn, you start your starting position, and then you take your 9 steps to the end. You do small steps, turn around, 9 steps back, and you're supposed to have your arms at your side. As you remember during the video, that we kept seeing this going on. He's trying to maintain balance, trying to walk that straight line. He's failing to maintain his balance without using his arms, which shows you that he's having difficulties with balance. When he's standing still, you see him swaying a lot. He was still standing still without swaying. The last SFST is the one-leg stand where he had to stand with his arm to the side and put one of his feet out and hold it parallel with the floor, about 6 inches off. And he's supposed to do that with counting out loud. During that, we also saw that when he was doing this, trying to hold on to his balance, try not to fall, is because he has lost his physical ability, his normal physical faculties to stand and perform the test. We don't have evidence of when he took his last drink. As I saw whenever Miss Alton Morano was on the stand, you can't do the test where they can determine how intoxicated you were at the time of your item, unless you have your lab. They can't do the extrapolation unless you have the lab. Unfortunately, we don't have that. However, we do know that in the 1.5 hours from the time of the stop to the time of the blood was drawn, he wasn't consuming alcohol during that. And during that time, that's an hour and a half, at an hour and a half later, his blood alcohol was 0.35, which is almost twice as much as the legal limit, which is 0.08. So knowing that he hasn't drank any alcohol in an hour and a half and his blood alcohol is still that high, the test result has merit, and it shows that alcohol was in his system beyond the legal limit. All right. Okay. So, as I was saying, these are the elements of the crime that we have to prove. And if the state has proven beyond a reasonable doubt with your common sense and your ability to reason that we have proven each of these elements, then you have to find the defendant guilty of driving while intoxicated. Thank you.
Okay. Okay, ladies and gentlemen, for the jury, before you go back into the jury room to deliberate, I must inform you that one person on the jury is an alternate. And that person is not allowed to go back into the jury room. And the person that is the alternate name is Nikki Hebert West. Was that? Okay. Okay. So if one of the jurors is unable to complete deliberation, then Ms. West, you'll be allowed to go in and complete the deliberation with the rest of the jurors. So you can, if you want to have a seat in the hallway or in the courtroom, whichever is convenient for you. So at this time, I'm going to hand this charge to the bailiff. And Okay. You can follow the bailiff into the jury room. The court will be in recess until the jury returns with a verdict. Everyone, please stand. Court will be in recess. Everyone, please stand. Miss, you can go sit in the jury box, but you still,
In the mix.
yeah, yeah.
Tell you. Sorry, this one went back to the box.
Okay, you may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session and cause number. What I mean, just hold on. Just keep it with me.
Okay.
Okay. Jefferson County Court at Law number 2 is back in session. The court is in session and cause number 24 CCCR 1826. Case of South State of Texas versus Logan Odebert. Let the record reflect that Mr. Odebert is present in court with his attorney, Attorney Ralph Kimler. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, and Attorney Andrew Hubel. And let the record also reflect that the jury is now present and seated in the courtroom. The court has received a note from the jury. Now, ladies and gentlemen of the jury, this court will be in recess until 1:30 tomorrow. So we're gonna ask that you come back at 1:30 on tomorrow. And when you come back, make sure that you sit outside the courtroom. Okay? So at this time, this court is in recess until 1:30 tomorrow. So everyone please stand as the jury exits the courtroom.
Recess.
Yes, court will be in recess until 1:30 on tomorrow.
See you tomorrow.
All right. Everyone, please have a blessed day.